All right, it's 10:01. Good morning, everybody. Hopefully everybody is now in the room, but first off, welcome everybody. Good morning. My name is Eric Gunderson, Director of the Office of Marijuana Policy, and welcome you all here. The purpose of today's hearing is to invite testimony from members of the public regarding OMP's proposed rule to replace and revise the regulations governing Maine's medical use of marijuana program. As you know, in early 2021, OMP commenced rulemaking related to the medical program. Ultimately, any of those changes to the program were delayed by the legislature, and OMP convened a medical marijuana working group, among other things, to advise on improvements to the Maine medical program and to fulfill the stakeholder engagement as directed by the legislature. So you've heard me say this before, one of our guiding principles is to develop and institute regulations that are necessary, not overburdensome. Ultimately, the discussions that working group helped guide OMP's approach to this medical rulemaking, and it are reflected in part in the rules subject to today's hearing. With that said, the purpose of today's hearing is to invite testimony from members of the public regarding the proposed rules which will govern the state's medical program. As you can see, I am joined today by fellow colleagues. Serving as a panelist for today's hearing with me is Vernon Malik. Vern serves as our deputy director of operations, overseeing both of our licensing and compliance teams. In addition to Vern, I'm joined off camera by Tracy Jakes and David Heydrich, who are supporting this call and pulling the strings with this Zoom meeting. So before we begin, I just have a few procedural items that I need to cover before we get going. First, in accordance with Maine Administrative Procedures Act, we're required to publish notice of proposed rulemaking in the Secretary of State's Notice of Agency Rulemaking. That notice for this hearing was published Wednesday, January 12th in the 5 major newspapers in Maine. Additionally, OMP announced plans for this public hearing via letter to program registrants on that same day, and more broadly in a newsletter to stakeholders on Friday, January 14th. The statutory authority for this rulemaking appears in Title 22 and is necessitated to align the program rules with changes that have occurred in the underlying statute in the nearly 4 years since the program rule has last been amended. Since that time, there have been numerous substantive changes to the medical program. This rule was last amended by the Department of Health and Human Services in February of 2018 and implemented in May of 2018. For the purpose of today's hearing, I'll be acting as chair, and as such, will make decisions related to the meeting and participation. We ask that participants be respectful and appropriate with their communications and activities. Those giving testimonies, your remarks should be limited to the rule under consideration today rather than attempting to rebut or refute testimony provided by others. Second, if you are streaming the hearing on YouTube at the same time you're presenting in the Zoom webinar, please mute and or close the window as you prepare to give that testimony. There is about a 20 to 25 second delay between events happening, so it can just be distracting or a nuisance. So just a heads up on that front. If you have stepped away from the meeting, if you have stepped away and the meeting is otherwise prepared to conclude prior to return, the public hearing will close. When it comes time to receive testimony, OMP will ask interested individuals to use the Zoom's non-verbal raise hand feature to identify yourself as prepared to provide your testimony. When it's your turn to testify, you will be elevated from attendee to a panelist to enable you to unmute your audio and enable your video. When this occurs, you will temporarily leave the Zoom webinar and rejoin with your elevated permissions. When that happens, please do not close the Zoom window to make sure that you're still there and able to give that testimony. If we have any participants joining exclusively by phone, when asked to raise your hand, it's *9, and to be recognized, and *6 to unmute your line. We appreciate your patience and understanding as we conduct this public meeting and confront any unexpected technical or human errors with this Zoom webinar. So we'll hear testimony from persons presenting who wish to speak neither for nor against, in favor or against the proposed rule. In addition to providing feedback on the form and content of the proposed rule, members of the public may also pose questions about the rule. At our discretion, either myself or Vern will attempt to answer the question posed through your testimony. If we cannot answer the question, we'll be certain to write a written reply within a reasonable time after the hearing to make sure that you get the answer. If you wish to testify, please state your name, town and residence, and organization, if any, before beginning your remarks. Public comment on the rule, both during the public hearing and written public comment period, should be limited to the current rulemaking activity. If possible, please be prepared or try to give us specific sections or pages of the rule in which you might be addressing in your testimony. That will help us consider that feedback and make adjustments to the rule as appropriate. So testimony for the public hearing will be received in the following order. Those speaking in favor of the rule, those speaking neither for nor against the proposed rule, and then those speaking in opposition of the proposed rule. So participants wishing to testify will be limited to 3 minutes. Please prioritize your comments to those most important to you. And you also may submit additional written materials to accompany your testimony. If we're unable to get it out all verbally, we'll certainly collect that and consider it as we go back and do our work. There's no limit on the amount of written testimony that you may submit. In the public comment period for this rulemaking activity will remain open until 11:59 p.m. on Sunday, February 13th. So just also please be mindful that today's hearing is being recorded and live streamed on the internet via YouTube. Additionally, written testimony submissions are public record and available to all interested parties once submitted. So now that we got through all those logistics, we can move into beginning the public hearing. We will now begin accepting public comment. Attendees are reminded the purpose of today's hearing is to receive public comment on the rules developed by OMP that govern the medical program. Comments on changes that should occur to statute or other rules promulgated by our office are not germane to today's conversation or proceedings. And with that said, I will begin the hearing. I would invite anybody testifying in favor of the proposed rules to raise their hand using the Zoom's non-verbal feedback, and then we will elevate you one by one into the room to provide that testimony. Hello, Randall. How are you?
Good morning. Doing well. Thank you for the opportunity to provide comments.
Absolutely.
I'm Randy Query with I'm Director of Government Relations at the American Association for Laboratory Accreditation, A2LA. I've been involved with laboratory accreditations for over 2 decades. On behalf of ATLA, I'm commenting on the proposed medical marijuana program rule as it pertains to laboratory sampling, testing, and accreditation. Overall, we are in favor of the proposed rules that you and your team arrived at. By way of background, A2LA is a nonprofit, independent third-party accreditation body with over 4,000 actively accredited certificates representing all 50 states and international, including 122 organizations that are accredited for cannabis testing. We have been granting accreditation to testing laboratories since 1979. In establishing and implementing and further refining a medical marijuana program, laboratory testing and the ensuing test results are critical to the program. Regular laboratory assessments leading to accreditation will provide the users of the test reports with confidence that the data is backed by a quality management system, technically competent sampling and testing, qualified personnel, and use of appropriate facilities and equipment. This is a consumer product, and to help ensure greater product safety, testing needs to be mandatory. Again, overall, we support the proposed rules. However, we respectfully offer the following comments to the proposed rules to assure more reliable testing results. First of all, under definitions, thank you for adding a definition for marijuana testing facility. We do recommend that it be further clarified by identifying the ISO standards. There's hundreds of ISO standards that exist, and we think that definition 44 part B should add language to say accredited pursuant to the current version of ISO/IEC 17025 by an organization that's a third-party accrediting body that is internationally recognized to the current version of ISO/IEC 17011. By adopting this language, you'd be more assured that a consistent approach is being initiated by all accredited bodies. Also, under when it's pertaining to sample collection, we think it's important that that sampling collection be collected by the accredited marijuana testing facility as allowed in 543B, but restricted just to that, medical laboratory facilities. This will ensure that the sample is collected appropriately, that there is oversight of that sampling process to ensure sufficient procedures are followed. Thank you for your time. I appreciate it.
Thank you for joining us today.
Mhm.
Fern, do you have any questions?
I do not.
Great, thank you. We will now elevate the next participant. So we had a few more register for in support of the rules. If you're wanting to give testimony in favor of the rules, please raise your hand now. It seems like there might be a few that aren't in the room or are not raising their hand. So if we don't see those hands go up, we'll move to neither for nor against. So we'll give it another, I don't know, 10, 15 seconds. Again, if you're wanting to provide testimony in support of the rules, please use the raised hand feature. Okay, with that, we will now move to those that are speaking neither for nor against the proposed rules. If you had registered and your testimony is neither for nor against the proposed rules by the Office of Marijuana Policy for the medical program, please use the raised hand feature now. There we are. Mr. Sumner, how are you? If you could unmute yourself and turn on the video if you feel comfortable. I believe you are a panelist now.
Thank you, Director Gunderson. Can you hear me okay?
Yeah, how are you?
Doing well, thank you.
Good.
Let me just get my get set up here. Good morning, ladies and gentlemen of the Office of Marijuana Policy. Thank you, Director Gunderson and Vern, for the opportunity to speak today. My name is Eben Sumner, and I'm a resident of West Baldwin. I'm here to submit testimony today as the legislative chair of the Maine Growers Alliance, as well as on my own behalf as a stakeholder. Additionally, I'm also an active member in the Cannabis Commission of Maine, a consensus group that's been created from the leaders participating in the majority of cannabis trade groups in Maine. I'm here today to speak in opposition of the Office of Marijuana Policy's second set of proposed rules. Just like last year's proposed rules, I've spent a fair amount of time going over this year's set. While smaller in length, it's not short on overreaching or overburdensome regulation. The majority question that I keep receiving and my colleagues continually hear from our various group members prods on the lack of data that would require a bevy of regulation that is posing to solve problems that we just don't see exist. Myself and the many small business owners, employees, and families supported by this industry want a safe and healthy and regulated market. We too have a mission, vision, and values. We believe it's important to our industry to develop a good faith partnership between the department and its stakeholders. We want rules and policies that provide patients access to a regulated and safe market, and those that diminish the unregulated illicit market. We want responsible policy that makes sense for the program, which is not overreaching or overburdensome. I'm sure this sounds familiar, as it's the Office of Marijuana Policy's mission statement and guiding principles. It's clear to me that we see eye to eye in our future goals for the program. And in order to keep progressing, we need to work together to achieve those goals in an effective and equitable way. In my opinion, that starts with seeking out the problems first and then finding fixes, just like all of us here do in our personal and professional lives. We've yet to be provided with those problem areas that need fixing, nor can we find them through our own research. I'll close my testimony today by repeating something I've said in my testimony last year when I was speaking to you out against the first set of rules. I'm looking forward to the day where we can take medical cannabis to a place where it should be, a functional and integrated therapeutic that proves time and time again to be a benefit to many people in many ways. I'm looking forward to the day that our industry is not stifled with an antiquated negative framework stemming from the war on drugs. I'll keep looking forward and working my hardest to get us there. Thank you for your time today. I will submit my detailed response and testimony.
Thank you, Mr. Sumner. In the conversations that we've had outside of these meetings, certainly I think we share that same sentiment, as it does seem like we want to get to the same spot. Just for the sake of getting a little bit more detail, are there any, and I realize you have your written testimony, I'm hoping goes into a little bit more detail. Are there any one or two initiatives within the proposed rule when you talk about overburdensome or not addressing a problem that you can just flag for us?
Yeah, I think I'm thinking the security is there needs to be some things ironed out there. The tracking as well. It kind of seems like, you know, even though we haven't mentioned metric, it seems like there's still some issues there. It's nothing that I don't think we can't resolve together. And I think the work group was a good start at doing that. And really, you know, a good show of faith. And yeah, there's a lot in this in the rules that I think are, you know, a little further than taking a step further than public health and safety. And but I think we'll work together and figure these things out.
And I got to follow up if that's all right with you, Mr. Sumner.
Yeah,
so I'm glad you brought it up, and I'm sure others on this call are going to, or this public hearing will certainly bring it up, the tracking piece. While we have moved away from metric, we do have a litany of things in the rule proposed as far as what we would expect to be tracked. And I'm sure it differs from registrant to registrant within the program. But are there some things that you, within your business and what you're doing, that you are currently tracking that would mesh with some of the requirements and what I think you probably understand we're trying to get at?
Yeah, I think a lot of the security pieces are covered in my businesses and probably a lot of people here. But it should be a market decision. I don't necessarily think there should be like steps of exactly what needs to happen from the state. You know, there's definitely a level of security that everybody wants for their own business, but you know, that's a market decision.
Okay. Vern, any questions for Mr. Sumner?
Oh, I don't. Thank you very much for your testimony, sir.
Yeah.
All right, thank you for your time.
Good to see you.
You too.
All right. Anybody else? If you're wishing to provide testimony neither for nor against, I know we had a number of registrations for neither for nor against, but we're not seeing any hands. So I will give it one last call. Please use the raise hand feature if you wish to provide testimony neither for nor against. And if we don't see any hands go up in the next, I don't know, 10, 15 seconds, then we can move on to those opposed. I see one hand there. It looks like you have been elevated as a panelist, Mr. Robinson. So if you could unmute yourself and turn on your camera, we will hand it over to you.
Hi, do you have it now?
Yeah, we were seeing a box of
Lunch bags.
Okay, cool.
Hold on a sec. Well, camera doesn't want to turn around.
No, that's okay. We can hear you just fine.
All right. Thanks, Director Gunderson and Vern. Thanks for the chance to speak. I had signed up as neither for nor against because I wasn't really sure where I came out on it. There are some aspects of the rules that I think are fine, but there are some where I think that there are a couple of sayings: "If it ain't broke, don't fix it," and "First, do no harm." A couple of the revisions seem like they're trying to fix problems that aren't coming to my attention from any patients. Things like the packaging requirements, where we're trying to simulate, I assume, what's done in other markets of portion sizing and all of this. Our patients are generally seniors. At least a lot of my patients are seniors, and getting jars that are child-proof that you can't open is the last thing that a lot of people want. If they've got arthritis, they don't want to get packages that they can't open. So I think, why do we have this extensive range of packaging and kind of portion sizing requirements when at least we're not hearing any kind of need for that? Second area was on the video surveillance requirements. I think we all don't want to be robbed. That's clear. We don't need to be told that we need 1080p video surveillance that's linked to the police department. We don't have a police department in our town. So linking it to the police department in our town is not going to do anything. Linking it to the state might help. But these monitoring systems are expensive, and I think you have to look at the benefit versus the burden of whether you're going to actually achieve deterrence by requiring all the videotaping of the facilities. The last thing to me was the tracking aspects. I think, as Evan mentioned, there should be a business purpose to why you're keeping track of things, and there are things that we do need to keep track of. But somebody has to do that. OMP is not providing people to do that. The customers aren't providing people to do that. So we have to do that. And every time that you have to make an entry or record a log or transaction, it's just more time that you have to spend doing that. And in a small business, your time is all you have to get things done. And if I have to spend more time logging that I moved something from one pile to another pile, or what plant it came from, all of those things seem to me like regulation in seek of a need rather than a need seeking to be regulated. So those are the points that I had. I think generally it's a good idea to update the rules. I would try. I think there's one aspect that you put in the rule that says basically contrary to Maine law. And Maine law, as I understand it, if something is not prohibited, it's permitted. But there's a catch-all phrase added to the rules that says that in regard to conduct related to medical marijuana, unless it's permitted by these rules, it's not permitted. And that seems to be kind of a reversal of the if it's not prohibited, it's allowed general concept. And so you're turning into more like a civil code statute that says, everything that's allowed is allowed and nothing else is allowed. And that seems to be putting a lot of burden on your regulations, adding things like substantive rules on drive-up windows. I know during pandemic, people were using drive-up windows. I noticed that there's a prohibition now for drive-up windows, and not sure where the need for that came from at a time when people are trying to avoid contact. We're saying that you can't have drive-up windows. I don't know whether there was a public outcry against drive-up windows, or where the motivation for some of these changes came from. So that's all I have. Thanks.
Thank you, Mr. Robinson. So one question again about the tracking. In your day-to-day in running a business, and obviously there's the record retention requirements and tracking, which is law. Is there anything that you do in your daily operations that overlaps with some of the tracking requirements in the rule?
I definitely want to know how much inventory I have. I want to know how much I've sold. I want to know how much I've destroyed. But which plant from which batch, kind of the labeling and extent of that, I don't really. Patients ask me for a particular strain. I know what strains I have. I know which plants they came from. I can trace it back if we're having a problem. We've never had any problems with any of our products, but if we did, I know which plants were which. I don't need to have a paper record of this plant yielded this much and went into this bucket and this was in this jar. Separating all of those things is just very difficult for a small business to keep track of. It's just me and my brother and my son, so there's not a lot of us to do all of the paperwork that's needed. We already have stacks and stacks of trip tickets. We're welcome to see those if they're any use, but I'm not sure adding more paper is really going to achieve the anti-diversion concerns.
Thank you. And then just one follow-up question, as far as the security requirements are concerned. Do you operate a storefront?
No.
Okay. Just to be clear, we're in
the process of seeking local authorization. The town doesn't have that. We haven't opted in yet, so we're in the process of opting in. Okay. Oh, great. So just so there's clarity for others that come, and we can certainly have the conversation, continue to have it. The security requirements are now just for dispensaries and retail stores. So if we have anybody operating out of their home or whatnot, they don't have those same video requirements. But certainly appreciate your comments. Thank you for joining us. Vern, did you have any questions for Mr. Robinson?
No, I just one thing to further clarify. I think if I heard you right, Mr. Robinson, you made mention of security cameras being connected to the police, and you don't have a police department in your town. Just to be clear, there's no requirement that cameras be connected to police departments, and I don't believe police departments want them connected anyway.
Well, no, it was connected to a service provider that's connected to a police department.
I'm sorry, can you repeat that?
The requirement was that you're monitored by a licensed company capable of contacting the registrants.
Well, that's for the alarm system. That's not for the video system.
Right. I use the video for the alarm. And it's not connected to the police department or a service provider. It's connected to my security people.
Okay, I understand now. Thank you.
Thank you. All right. So is there anybody else that's wishing to provide testimony, neither for nor against? Please raise your hand. Looks like we have one. Perfect. Mr. Gould?
Hi. Hello.
Hey, how are you?
I'm doing well. I guess I figured out this Zoom thing just in time.
Perfect.
I wanted to talk. My name is Greg Gould. I work for Silverchild Consulting. I'm a consultant in the cannabis, both the adult use and the medical world. So I teach people how to make edibles and how to do things like that. And I want to say that I appreciate OMP's desire to bring a little bit of accountability and transparency to the medical marijuana industry. I think that that's, pretty reasonable. I wanted to talk a little bit about testing and a couple of things revolving around me. I am concerned about the cost of testing. I think that's something that you just shook your head. Yes, you understand. I think that it's obvious that it's gonna hurt a lot of people. It's gonna be really challenging to keep the price of cannabis down for the patients with the cost of testing. So if you have to implement it, I would like to see the state possibly set the rate of testing, keep it affordable for everybody. The smallest caregivers shouldn't have to test. If you've just got a few patients, don't worry about it. But it's very important that the fewer the units you have, the cheaper the test. Make it reasonable, make it affordable, because if it's not affordable, then the price of cannabis goes up, people go to the black market. So you gain and you lose, gain and you lose. One other thing I wanted to, so it's really important that if you implement it, and I'm against implementing it in this form. And another thing that's really important to understand is that I don't think that the testing companies have the infrastructure to do it. And I think that people will be looking at 4, 6, and 8 week delays to get their stuff tested. And I want to know that the testing facilities can actually manage the massive influx of products that you would require if everything has to be tested, because I don't think they can. And I think that's going to affect both industries. I think that's really important. The last thing I wanted to talk about is in specifically when it comes to manufactured products, that if you require everything to be tested, then once an oil or something leaves a lab, the only testing that a manufacturer should have to do at that point is potency testing. There should be no need for any additional testing of contaminants or metals or any of that stuff. Just potency testing. Everything else is it's kind of like double dipping for testing. In my industry, we're running into something where the chocolate has cadmium in it naturally. So even if the oil tests fine, the food is testing a little wonky. So we need to make sure that if the oil that a manufacturer gets is clean, then it's clean. We don't, test for any of those things in any other product, to my knowledge. So I do want to say that I don't think that the testing can be implemented, and I don't think that the labs could probably handle it for quite some time. I think that there's going to be a massive backlog, and I would rather see the state set up their own lab for the medical community. I think that that's pretty reasonable and a way that can take the profit out of it so that the patients aren't paying a lot of money. I can't really afford my cannabis to go up anymore. I don't, even though I'm in the industry, I don't make a lot of money. So I wanted to say just that the testing that's in the rules isn't going to work. It's unmanageable, it's expensive, and there's double testing. But I do appreciate your desire to bring some transparency and accountability to the industry. I just don't think that these rules work.
Great. Thank you, Mr. Gould. And just for clarification, there's no proposed mandatory testing regime for the medical program in these rules. We're simply taking the first step as far as essentially those labs that we have certified by the CDC, ISO accredited in the adult use side, could serve as medical marijuana testing facilities. But there are no testing requirements or required panels or analyte types. That was a subject that was discussed in depth at the working group that we did have. And I will say one of the biggest concerns that was brought up was certainly the costs associated with it, that impact for patients and access. So if we were to ever do it, that would certainly be a top consideration of how to do it. But I just want to make that clear. So I guess the one question I do have for you, Mr. Gould, if done right, would you be supportive of some form of testing in the medical program, or are you just kind of leave it up for a business decision?
I would like, if you have time to reach out to me, I have some really good ideas about testing that might make it manageable. So if the rules were reasonable and it didn't raise the price for the consumer and it was manageable by all parties, then, anything that can bring a little bit of anything that's good for the consumer is good, right? But the cost of cannabis going out of control and driving people to the black market isn't good at all. And putting small business isn't good. So I tested my products pretty regularly when I was making edibles on a very regular basis to make sure that what I was doing was pretty accurate. But I could never have done everything. It's just not manageable.
So you did when you were producing edibles, you were doing some level of testing?
Yes, absolutely. I was making sure that at least my potency was dead on as much as I could. And I think that was something that people appreciated with me. And that's one of the things that I am now providing to my clients. Hey, this is how you get, a pretty good and safe product to the market that's totally accurately dosed and isn't completely burdensome. So in conclusion, if anybody out there watching needs an edibles consultant, reach out to me.
Okay, we appreciate you being here and providing comments. Vern, do you have any questions for Mr. Gould?
No, not really a question as much as just a follow-up comment that what we've inserted in the rules in Section 8 regarding testing is exactly what's required in statute, which says that if you're going to make potency claims, you have to have that supported by testing. So it's really not an effort to expand on anything, like you already said, Eric. So I'll stop being redundant.
Great. Thank you, Mr. Gould.
Yeah, reach out if you have any more thoughts you want to talk about. I'd love to speak with you about it. Thank you very much, and have a great time.
Take care. Thank you. Take care.
All right.
All right. Neither for nor against. We can elevate the next to provide testimony. Neither for nor against. Please raise your hand. Attendees that are looking to provide testimony, neither for nor against. There are hands going up and down. I think we'll get one here shortly. Hello, sir. Is pronounced Mr. Hom?
Yes, this is Dr. Hahn.
Well, welcome. The floor is yours.
Thank you very much, Eric. My name is Dr. Sherman Hom, and I am the Director of Regulatory Affairs for Medicinal Genomics. We are based in Beverly, Massachusetts, and we produce test kits for the cannabis laboratories to test cannabis for microbial contamination. I have reviewed the required tests that your state has as required testing, and I've noted 5 particular tests. 4 of them are total counts, that being the aerobic microbial count, the total yeast and mold, coliforms, and total enteros. And also total E. coli. And so I have been communicating with legislators and regulators throughout the country to share, specifically today, to share with you that a result from these tests do not provide any information whether there are any human pathogens in these cannabis samples. And it would be a shame to have a consequence against, not against, but for the cultivator if you don't know one way or another whether it may hurt or make ill a Maine patient participating in the program. And I will be submitting suggestions to your program as to the human pathogens that 7 states have now put as required testing, that being 4 pathogenic strains of Aspergillus. You do have Salmonella, and there is the most pathogenic E. coli, being Shiga toxin producing E. coli of the 6 pathotypes. And so I just wanted to share this with the Office of Marijuana Policy. Many states are circling around now to modify their required testing after their initial round. I worked in the New Jersey cannabis program, medical cannabis program, since 2011. I recently joined Medicinal Genomics just last year in May. Thank you very much for your time.
I appreciate the testimony. Just again, to be clear, it sounds like you might be looking at our testing rules for our adult use program, in specific when you're talking about micro. None of that is required in our medical program currently. That would be a conversation with the legislature if and when they decided to incorporate that. But I certainly do appreciate the comment and look forward to your written testimony.
If I may, it is difficult. You know, I started in May and I'm trying to cover 38 states. And thank you very much, Eric, for making me aware that the Maine medical cannabis regulations do not require any microbial testing. That is very interesting to me because of the the ill patients, and some of them being severely immunocompromised. That is something that I hope that the Maine legislature rectifies as soon as possible. I hope.
Vern, any questions for Sherman?
No, I would thank him for his testimony and look forward to reading what he has to present us.
I will get it in by the 13th.
Thank you so much.
Thank you.
Thank you for your time.
Is there anybody else that wishes to provide testimony neither for nor against the proposed rule? If so, please use the raised hand feature, and we will elevate you to a panelist to provide that testimony. Neither for nor against. Please use the raise hand feature. If not, we will move on to those wishing to speak in opposition to the proposed rule. Okay, seeing none. If you're wishing to provide testimony in opposition, yeah, there we go. If you're wishing to provide testimony in opposition to the proposed rule, please use the raised hand feature and we will elevate you one by one in the order I believe that you raise your hand. There we are. Brett Messer, how are you?
Good. How are you doing today?
Good. Thank you for joining us, and I will give you the floor.
Thank you. Good morning. Thank you for the opportunity to provide comment today. My name is Brett Messer. I've been a caregiver for 10 years, a medical patient for 13 years. I own and operate Bridget Farm, a vertically integrated cannabis company located in Saco. I'm a member of the Maine Craft Cannabis Association, Maine Growers Alliance. I'm also a graduate student of medical cannabis science at the University of Maryland School of Pharmacy. Unfortunately, we're back here again today defending the medical program. Last year, a very similar set of rules was tried to be forced upon our program, and our industry fought tirelessly alongside many great legislators to defend its future. The passage of LD 1242 is why we're here today. Unfortunately, the medical work group that was assembled was not representative of the stakeholders within the medical program. And I believe if the office had actually listened to medical stakeholders up front, they would realize many of the rules proposed here today are a death blow to our industry. Isn't that what some people want, though? Let's talk about conflict of interest for a minute. Here's an excerpt from an article in a well-respected medical journal recently published about cannabis legalization. Conflicts of interest can powerfully bias decision-making. Modern drug regulation is designed so that decisions about medication approval and regulation are made by individuals who will not directly benefit from these decisions. Many state politicians receive campaign contributions from marijuana business interests, and state governments that legalize marijuana stand to generate tax revenue because of it. In cases in which state governments act as drug regulators, it is often unclear where the lines are drawn between the people who make decisions related to legalizing cannabis and the politicians who appoint them. So with that, the very largest cannabis companies in the world, which operate here in Maine, have a track record of contributions to politicians and lobbyists which seek to overregulate the medical program so that cannot effectively compete with the adult use program. Maine's medical cannabis industry is the best in the nation, as frequently reported by Americans, for safe access. Our prices, the quality of our products, and safe access cannot be matched anywhere in the country. We do not need to fix what is not broken. One argument is that these changes are found in statute. What you will find in my line-by-line examination of these proposed rules is that many of these are not found in statute. Another reason that it's frequently argued for the need for changes is due to public health and safety. So I beg this question: where is the risk to public health and safety? Where is the data? There is none. There are no deaths. There's no abundance of hospitalizations, no major movement in traffic fatalities or underage consumption. So where is the data that supports the need for these changes? This past year, the OMP made significant changes to its medical application process without consulting the legislature. They issued no guidance documents. I have renewed my caregiver card 9 times. It's never taken more than 30 days. From the time I began my renewal to this time, I received my card nearly 4 months later, including it taking a month to be told I was missing a signature on a business formation document that was not previously required, and an additional month after the signature was provided to actually deliver the card. Another major issue is that OMP inspectors, for whatever reason, work in both the medical and adult use program. Inspectors are frequently confused and incorrect about the differences between the medical and adult use rules and laws. Why does a $300 million industry not have its own dedicated inspectors? What does all this add up to? Well, quite frankly, there's been a poor track record of administering and enforcing the current rules. So I'm wondering what the plan would be to enforce and administer additional rules when even something like a minor change in licensing has been a disaster. I would agree that there's the need for some additional rules, and certainly many of the rules found within this proposal are not going to work for our industry. So I'm sure you're looking for some specific examples. I have about 8 pages of a line-by-line analysis of each portion of the rules. I will highlight a couple just briefly. One of those is business formation. Specifically in statute, it says a caregiver may organize as any type of business, yet this rule says that we cannot. Another is with labs with an arbitrary limit of 40 or 200 pounds in possession of the lab. Our lab processes about 100 pounds in a day, and therefore we'd only be able to keep about 2 days of work on hand. I believe that if a trip ticket is with the material, which indicates the owner of the material, then there should not be an arbitrary limit for an extraction lab, which is simply providing a service to other license holders. Thank you for the opportunity to provide testimony today. I will submit a more detailed written testimony, and I'm happy to answer any questions.
Yeah, thank you for the written testimony that we'll be submitting. And just one thing, I'm sure it's not the only time it's going to be brought up as far as the possession limits for the manufacturing facilities. Those are for essentially standalone manufacturing facilities, so they would not apply to your caregiver operation. That's certainly an area of law which we would like to work with the legislature to fix and to clarify. But I'm sure you're not the only one that sees that, and we can be more clear of how that would impact our current registrants within that. Vern, did you have any questions for Brett?
No, I think you covered it. I was just going to address the issue around standalone manufacturing, and the limits are actually statutorily drawn for us. Those were not developed by OMP.
Correct. All right. Thank you, Brett.
Thank you for your time.
All right, we will elevate the next individual who wishes to speak in opposition to the rule. Muted myself. Jennifer Bergeron, you are a panelist.
Okay, thank you. My name is Jennifer Bergeron. I'm from Winslow, Maine, and I'm the co-chair of the Maine Cannabis Coalition. On January 12th, caregivers received a letter from you, Director Gunderson, which sounded like an olive branch was being extended to patients and caregivers, and gave me hope that we were on the path to rules we could all agree on, or at least a good start in that direction. Then I read the proposed rules, which in my opinion are not significantly enough different from the last proposed rules, which were met with fear, shock, and a resounding no by most patients and caregivers. And then it was met with a resounding no by the legislature. I don't know if you remember the movie It's a Wonderful Life. Receiving that letter was like Old Man Potter offering George a really cushy job. But then reading the new rules was like when George shook his hand and realized nothing had really changed. He was still up to his old tricks. And I'm sorry, I don't mean to say you're up to tricks, but that's how it feels. Although we want many of the same things, changing the rules this significant, it can't be sustained by this industry. This industry kept our economy going during the worst part of this pandemic. The caregivers I know all spend their money locally and generously. Some people ask if we need to keep fighting this battle. Can't we just take these proposed rules and use them as a starting point to get where we need to be? Unfortunately, we can't. The rules, when passed, seem to always be interpreted in the worst and most stringent way possible when it comes to enforcement. And I'm going to give you some examples. If a caregiver storefront sells edibles made by another caregiver, they need to have a commercial kitchen license. Why? Who knows why? Even though this makes no sense and seems to be an obvious error, this has been enforced against caregivers anyway. Caregivers cannot have advertising on their vehicles. We're business owners. A storefront can have a sign on it with a logo, but once it's on a vehicle, it's somehow geared at targeting someone under the age of 21. A caregiver can't meet a patient in an agreed upon public location. All caregivers who have transactions to the public must purchase scales, which are certified by the state of Maine Department of Ag. It doesn't matter if the caregiver is small, only has a few plants, only transacts from their home and to people they know and who trust them. There aren't exemptions to this rules, and the scales cost over $500, which is a burden on many small caregivers. I've listened to tapes from when HHS committee was talking to municipalities about municipal authority over caregivers. And I know that the intention of giving municipalities authority was not to allow them to charge a licensing fee to home-based caregivers, but was specifically a response to caregiver storefronts popping up, and was meant to allow municipalities to regulate these as well as extraction labs, etc. A representative from the MMA can be heard on the tapes making the agreement that home-based caregivers are not something they have any authority over, but as soon as the language was passed and it was a little ambiguous, suddenly the MMA began advising towns that they have that authority, and many towns are now charging home-based caregivers a fee. This is why we can't start with bad rules and adjust them on the fly to correct any overreach. We need real representation at a stakeholder meeting, which does not include members of the adult use community and instead gives both patients and caregivers a real voice and a path to implement changes in the program in a manner which ensures the continued safety of the program and at the same time protects participants. I do have written testimony and will be submitting it, which goes into specifics about these rules. I think that we can come to an agreement on many of the issues, but I don't believe that stakeholder group represented the true stakeholders in the medical program. Thank you.
Yes, thank you, Jennifer. Again, just want to point one or two things out. As far as the commercial kitchen and scales, not Title 22, it's Department of Ag statutory language. And local control is more based around statutory language as well. Certainly hear your concerns and thank you for your feedback, and I'm sure you'll provide written testimony. And as far as process is concerned, anytime we do the rulemaking or have these public hearings, we certainly do go through them in a good faith effort. We consider all of the feedback we get, no matter what the rule is, and we'll continue to do that as transparent as possible, the way we've done it in the past, making sure people can see those changes and how we've considered them. And so thank you for your feedback. Vern, did you have any questions for Jennifer? You're on mute, but I think I can read your lips. Thank you. Thank you, Jennifer.
Thank you.
All right, we will elevate the next attendee to panelist to provide testimony in opposition of the proposed rule. Here we are. Grant Smith Ellis, thank you for joining us.
Thank you, Director Gunderson and members of the OMP staff. Firstly, for providing the accommodation in the form of live transcript on the Zoom, again, for this public comment session. For folks, patients like myself who are disabled, it's extremely helpful. My name is Grant Smith Ellis. I'm a visiting qualifying patient from Massachusetts. I have family in Maine. And I spent an extended period of time while first recovering when I fell disabled in Wells Beach up in Maine. And it was because of access to low-priced cannabis medication through my caregiver at the time that I was able to avoid using far more substantial medications that could have potentially derailed my life. So the reason I'm testifying today is first, there was a small change to 2.1.1, which is related to visiting qualifying patients. So I really felt compelled to come in and talk about that. The statement pursuant to a law recognized by the department, I'd urge you to strike that. I think the statute states that all out-of-state medical cards can be accepted in Maine, and I don't think the department should get involved in looking at other states' laws and determining what should be recognized and what shouldn't. I think that'll undermine patient access. This was raised earlier, but I want to address it with a degree of specificity. Section 5.1.1N that talks about caregivers can organize as a business entity in accordance with section 6.2.2. So I want to talk about 5.1.1N and 6.2.2 A, B, C, D, E, and H together. I think you should strike those 6.2.2 A, B, C, D, E, and H. And I think you should change 5.1.1N. Instead of saying organize as a business entity in accordance with section 6.2.2, say what the law mandates, which is organize as a business entity in accordance with Title 22, Section 2423, A.2, because that clearly indicates caregivers can organize as any type of legal business entity recognized under the laws of the state. So I don't think it's healthy for the department to get involved in dictating which types of business entities caregivers can register as. The reason I bring that up is both of those issues will have an impact on the end price for patients like myself. So I encourage the department to shift those. Section 7.2 A through O is basically metric without saying that metric is required, which is also going to pass on prices, higher prices to consumers. And then I also want to talk about how 8.2 and 8.2.2b basically constitute mandatory testing because of requiring for edibles dosages to be indicated on the labeling. So those are my general areas of concern. They all relate to passing on these costs to patients, which will inevitably happen, which is going to undermine the ability for folks like myself on a fixed income to access medication in vital moments. So thank you for the opportunity to testify. I'm grateful for the chance to do so.
Thank you, Grant. Just for my note taking, when you first talked about 211, the language addressing qualifying patients, you had a phrase, like 3 or 4 words that you recommended the department strike. Can you just repeat those?
Yes, let me pull up the text specifically where it says, so I'll read this, the 2.1.1 and then just note what I'd like struck in. It says a visiting qualifying patient from another jurisdiction that authorizes the medical use of marijuana. And then I'd like the following few words struck: pursuant to a law recognized by the department.
Great. Will you be providing written testimony too? I did jot down, but a lot of times my notes look like chicken scratches.
Yeah, I recognize I went through I tried to be as specific as I could with the sections. So I'll also provide written testimony because I know there were a lot of numbers and sections in there.
And then the last thing, not a specific question for you, Grant, but for general awareness, because I'm sure we'll get more testimony in opposition to 6.2 and the business entity piece. We understand that that was going to get a lot of attention, got a lot of attention last time. Really, and I think I shared this last time we went through this process, as far as there being a perceived, well, not perceived, but a conflict in law. So pushing the issue to get that clarity that we need, understanding that these rules will go in front of the legislature that require that interpretation. We understand the impacts of what that might be. We understand that certain businesses out there are not in compliance with that. But we're simply looking for clarity around what the legislature intends or really wants with that piece. So I'm sure that conversation will continue. But thank you, Grant, for providing that testimony. Vern, did you have any follow-up questions?
Not a question, just more informational than anything else from Mr. Ellis. The section that you referred to on visiting qualifying patients and the suggestion that we strike that language is lifted actually directly from the statute, from the state law. That's not anything that we created on our own. We're quoting the statute there. So I don't think we're able to really strike that.
Great. Thank you, Grant.
Thank you for the time.
We can go ahead and elevate the next individual to a panelist who's wishing to provide testimony in opposition. Tammy Smith, seems that you're a panelist. You should be able to unmute yourself. There we go. And camera, there we are.
Hello.
Thanks. Hi.
Thank you for allowing us to voice our opinions. I am a registered caregiver with a storefront in a small town, Detroit, Maine. My biggest concern is the patient confidentiality. I think some of the rules do invade that a little bit. One of them being, I read under 6.1.3 under the security. And if you go down to D, all videos are subject to inspection by any department employee and must be copied and provided to the department on request. and that we have to keep 45 days of video. You're taking video of patients who believe that they're in confidence that can be viewed by anyone in the department. 45 days is extreme as far as the cost of storing 45 days of video. I currently have a 7-day system. We have cameras throughout our store, and yes, we do record, but to expand that to 45 days storage is a significant expense. Also on trip tickets, when you deliver, having the patient's address and not being able to meet. I wasn't aware that you couldn't meet in a public place. I missed that when I was reading through the rules, but not being able to meet in a public place and having to put a patient's address affects their confidentiality, I believe. It also makes it difficult for the caregiver who's delivering. If you're delivering to a new person, you're putting yourself at risk by going to someone's home that you don't know. That's why I had always met in a public place before I opened my storefront, for protection of my driver and myself. My other concern is having these rules become so cost involved for the caregivers and the storefronts that we do have to raise our prices, and that will push more people to the black market where there are no rules. And basically that's my concern, is the patient's security, our security, and the cost to the patients. And the child resistant packaging, someone mentioned that before. It is difficult for the elderly people to get their packages opened. And that is a concern for me as well. I do have a lot of elderly patients with arthritis who cannot open certain things. And I will submit written testimony that is more detailed and more specific. But those are what I want to go over.
Thank you, Tim. That was excellent as far as giving us concrete examples. Thank you for providing that testimony. Just your first point to the security is as far as it comes to patient privacy, because we certainly take that serious and understand that's a cornerstone of the medical program here. Is it the fact that the office would have access to the video, or is it the language where it's able to be copied and taken out of the store?
Where it can be viewed by any department employee. That it can be copied and viewed by anyone in the department. And
Okay.
What happens to that video once it leaves my store? Can it be used against those patients in some other way?
Okay. Thought I had another question for you. Vern, did you have any questions for Tammy?
Just a couple of comments. One thing that I wanted to point out, and I don't know the kind of security system or video system that you have. There is an allowance in the proposed rule that would allow the cameras to be motion activated. I've discussed that change with folks in the security industry that install systems professionally, and they've told me that that's really a game changer in allowing people to get much smaller systems and have it be more affordable. So that may be something that might, if the rule goes into effect as it's written, may be beneficial to folks to know that it can be motion activated. So if nothing's going on, there's no recording, which saves a ton of storage space.
Yes.
The other thing that I wanted to just mention is that the requirement that packaging be child resistant is found in statute. There's a statutory requirement. That's not new. It's been there for a very long time. And it's not new in the rule either. So just so we understand, that's not really an expansion of what we're trying to do in that regard. So just wanted to touch bases on those things. And then just lastly, patient records are confidential, but they're not confidential from the department, from OMP. We still need to know who you're providing product to. And there is a statutory requirement on us that we keep that information confidential. So,
Okay.
so there are protections put in place to allow us to regulate, monitor, but also protect patient confidentiality. It's one of our top priorities as well.
Okay.
Yeah.
That threw me where it said any department employee. So by any employee, it could mean the janitor. I'm sure they don't have access to your computer system, but that concerned me where it said any department employee.
And
It should be a,
Yeah, I can certainly see why you would have that reaction or get there. And that's something that we could certainly clarify. But I'm glad Vern did jump in because we do have a statutory directive to ensure patient confidentiality. So that's certainly something we could circle back to help address some of those concerns that I'm sure you and others have. So thank you for that.
thank you.
Yes, take care.
You too.
All right, we can elevate the next individuals. And I will actually go down and list off to help give heads up. I should have been doing that from the beginning, so I do apologize. As I'm sure people have joined before, I'm not the greatest with names, so I'll try to do my best. But the next three are Lestat Roberts, Paul McCarrier, and John Arnold. And it looks like we have a Michael Bates.
Hi there.
Hello. How are you?
I'm living the dream, my man. How are you?
Oh, good. The floor is yours.
All right. My name is Michael Bates. I am the head grower for Game Bred Cannabis. We're based out of Vassalboro, Maine. I'm also a registered caregiver. I just got my card this year. I'm a veteran of the United States Army, 10 years as an infantryman, multiple combat tours. Cannabis has quite literally saved my life. So it's an issue that I'm extremely passionate about, especially as potentially a small business owner. I have 3 children. So the reason I bring all of this up, small businesses tend to start at the home, regardless of industry. Cannabis is no different. In the proposed rule, we've hit on it a bunch of times, but all the added security layers, that's expensive. That's going to come right out of the pocket. And economics tells us that a business entity is going to pass on any increase in cost to the consumer, as another panelist already brought up. I find that these requirements are burdensome. There's going to be a cost associated for this. And as we all know, cannabis is still federally illegal. It's not like I can go get a small business loan to cover this. I have to find a private investor. So any of these costs to start my business, whether it's a grow or a retail store, that's burdensome. One of the other things that I noticed that caught me by surprise was the format of the proposed rule versus the format of the existing rule. It's extremely difficult to do a side-by-side comparison and go line by line and see what's different. Now, you say you're acting in good faith. I'm inclined to believe you on a first meeting. I don't know you, but it would appear to say someone that's ignorant that would be an attempt to obfuscate the change. Now, it seems to me to be a lack of transparency. One of the other things that I don't like in the proposed change from a grow standpoint, I paid $1,500 for a 500 square foot canopy license. I should be able to get all 500 square feet. If I'm in a building with other caregivers, it shouldn't matter if we share cultivation space, especially let's say that my fiance gets her caregiver's card. We have our own building. The rule, one of the proposed changes is that her and we share a dwelling. We can no longer share cultivation space. That's silly. What am I going to do? Build another building with a small business loan that I can't get? That's absolutely burdensome. We're also not allowed to form co-ops or work in partnership with each other. I think that that's absolutely silly because that gives the wellness connections, the Canuvos, the large out-of-state dispensaries a leg up on us, and we can no longer compete. Also, if I manage a 500 square foot canopy and I can be successful as a grower and I can bring my product to market and people want my product, there's no avenue for me to expand beyond a 500 square foot canopy. As a head grower, I manage my own space as well as the spaces for 2 other caregivers. I should be able to handle all of that on my own on one license if I so choose and if I can successfully bring my product to market. It's the spirit of free market competition. I think that the market should be the one who picks the winners and losers in this respect, not some arbitrary license that someone pulled out of a hat because that's what they were feeling that day. I'm sure it was a little bit more complex than that. I think that one of the reasons that I also bring it up in this way, I had no intention of moving back to Maine after my military career. If you are not over 40, have one foot in the grave, or are a mid-career professional, there's very few opportunities outside of the tourism and service industry here. Cannabis coming to the forefront here in Maine and becoming our #1 cash crop provides my generation and younger generations with the possibility to really be financially successful and entrepreneurially successful. And we should foster that as much as we can. What it seems to me is that the state is using the marijuana program, whether it's medical or adult use, as a way to line its pockets to deal with the aging population issue that we have. Because aging populations have needs with like Medicare, Maine Care, all of those things. That requires money. So you're going to tax the living crap out of us and take fees out of us because Maine's 2,000 caregivers did something like $250 million in sales during a pandemic. That's ridiculous. It's pretty clear we're a pandemic-proof industry. I don't think that the medical program should in any way, shape, form, or fashion mirror adult use, especially with regard to tracking. Metric has been brought up. Metric is being sued in multiple states because the contract allowed essentially a monopoly. Also, think about this. I've noticed on your board, there's not a single one of you has a background in cannabis, be it cultivation or anything. You are a poli-sci major. Vern is a 35-year veteran of the police force. I feel that some of that experience, well, I'm not saying that Mr. Malik is biased, but he spent 35 years fighting the war on drugs. Is that the guy that I necessarily want regulating my business? He might have a bias against it. I'm not
Michael,
saying that's
I've let you go about 2 minutes over your allotment, and we've gotten into testimony that has nothing to do with the rules. So I'll give you. Do you have anything?
My apologies.
That's okay. Vern, do you have?
With these rulemaking effort, you guys should approach this from the standpoint that cannabis is legal. We shouldn't be hiding it. We shouldn't be acting like it's shameful. It's either legal or it's not. Let's treat it like it is.
I will say I agree with you 100%. Certainly is legal, but we've also been put in a place where we've been asked to regulate these two programs, and there is a balance between allowing people such as yourself to flourish, but also understanding that there needs to be some transparency and accountability. And we continue. Sure. And I'm sure, well, this is your first time joining us, so welcome. But other people have heard me say this once. They've heard me say it 1,000 times. We really are operating without a rule right now. 2018 rule is vastly out of date and does not mirror what the program is today in the statutory language. So you've heard us say a lot of times that's statutory. That's simply us trying to catch up and align the rules with statute. I know some people think we've gone too far with certain aspects of the rule, and that's why we go through this process. And then also a reminder the legislature at the end of the day will take possession of this rule as well. But just want to set that as a baseline. Thank you for providing testimony. Vern, did you have any questions or clarifications?
Yeah, I had just a few clarifications I wanted to kind of throw out there. Thank you very much, Michael, for your testimony. A lot there to unpack, but just very quickly, if I could, many of the things that you mentioned regarding collectives, shared cultivation space, and taxes are all statutory requirements. We've not expanded anything around collectives being prohibited. The language is lifted directly from statute. The same thing as far as shared cultivation space. That's a statutory limitation that we face. The security requirement that is proposed would not impact you as a caregiver unless you had a testing facility or you were a retail store. So we recognize what you said earlier, which is, for a small business person just starting out, this could be, cost prohibitive or overly burdensome. That's not a requirement for a person just starting out. And as far as the taxes are concerned, taxes on medical marijuana are exactly what they are on any other product the state of Maine, 5% sales tax, 8% for edibles. So, and again, those are not addressed as part of the rule, but I wanted to throw that out to you to let you know that, we're not really expanding those areas.
And I'll just piggyback on that. Since OMP has basically come over, we've only lowered registration fees in the program. Thank you, Vern. Thank you, Michael, for being here. I hope to see you again.
Thank you for the opportunity.
Absolutely. Take care.
You too.
All right. So the next three that we have in the queue, Lestat Roberts, Paul McCarrier, and John Arnold. Lestat, I believe I'm pronouncing that correct. You are a panelist now, so you should be able to unmute yourself and turn on your camera. Here we are. We can't, I don't know if it's on your, I'm guessing it's on your side. We can't hear you. I'll give you a minute. Still can't hear you. Unless it's me, Vern. Do you have the wrong input device selected on Zoom? No. Well, we certainly, no. Lestat, can we put you back into the lobby, circle up, and once you get it fixed, raise your hand again, and we'll elevate you as soon as you're able to get it worked out. Cool. All right, thank you. So we'll come back to Lestat once we get the audio worked out. So that's going to put us at Paul McCarrier. And then the next three after Paul are John Arnold, Mark Barnett, and David, oh goodness, Vileu. I'm sorry. But let me pop over here. Paul, welcome.
Thank you, Director Gunderson and members of OMP staff. My name is Paul T. McCarrier. I am an operator of One Mill in Belfast, Maine. I've been a caregiver for 11 years since the inception of the program. I was also a member of the Medical Marijuana Working Group, which I thought did have some productive discussions around statute. I wanted to thank the department for going through and taking out some of the pieces of the proposed rules first, as much as I am opposed to this current draft, removing the sections on operating plans and the standard procedures, the visitors and vendors being escorted around, some of the most language related to the main patient medical providers being removed, being required to report illegal activity, and all references to inspections by law enforcement without a warrant be removed. I think you guys definitely were on the mark with that. And so I thank you for that. And I think that we still have work to do, and I will be able to give details in my written testimony, but I'll be giving a broad overview right now. So OMP's philosophy when considering future medical marijuana program rulemaking is one of the 5 principles is to develop and institute regulations that are necessary but not overly burdensome. I believe what you've heard so far today and what you will continue to hear is that many of the regulations within these proposed rules are both that unnecessary and overburdensome. Primarily, we're looking at ones that are involved with the tracking requirements, the idea that you can only be limited to a single cultivation area, some of the ideas on the tracking and the packaging. And when we're talking about the need for a data-based system and data-based rules. You know, as we know, Maine has over 100,000 patients right now. And from what we've seen from the data that was presented during the work group from the Maine hospitals, we have less emergency room visits, both inpatient and outpatient, than aspirin and other over-the-counter medications. And so I think a lot of these regulations, while I think they, you know, coming from a regulator standpoint, they may make sense to you, they don't make sense to the small business operator. As I think Mr. Malik can agree to that when the idea of the gateway theory of the gateway drugs is that the danger of people encountering other illicit drugs when purchasing cannabis was not that they would just use cannabis and then want to use other drugs. It would be when they were buying cannabis illegally, they would be exposed to other drugs because those drugs are being sold by drug dealers. Now, that is the biggest concern we have here, is that with these regulations as presented would significantly increase the cost of doing business for legal operators, tax-paying businesses in the state. And if those costs were passed on to patients, we could see those costs driving the patients to the illicit market, where they would not have access to continue to be legal cannabis, tax cannabis, but they also could be possibly exposed to other drugs. When it comes down to packaging, I think it's important to note that as you bring up this mentioned statute, you do mention that it has to be child resistant, but it's under the definitions 1-E. It specifically says in the last sentence, it is not to be significantly difficult for a typical adult to open and reseal. And that is something that I continue to hear from many patients, is that even with the child resistant packaging that we currently use, there is still some difficulty getting into it. So people have to use scissors. And essentially what they are doing is then taking that packaging and transferring it to their own packaging that they have at home. This would also then potentially prohibit patients from bringing in their own packaging for the cannabis that is being served deli style to be served into. And that is something that a lot of patients who are environmentally aware, who don't like pollution, want to be able to use their own packaging. And so we want to be able to continue to allow that to happen. I think when we're looking at the idea of tracking, is that we need to try to have a deeper conversation with the department about what the department needs to track, what the department needs to know about. One of the things that we have looked at is that the idea of tracking the flour, the concentrates, and the edibles, and what is sold. And so therefore the department could be able to get that data and be able to have a data-driven approach for when they're developing other policies. And that would also just, help them determine when communicating to people in the public health sector, what is being consumed here in the state of Maine. As we've seen from the trip tickets, is that the wholesale transactions are already tracked. And so that is something which I would be hoping that the department could possibly look at having some sort of department run, not with a third-party vendor, portal where we could use electronic trip tickets or have some sort of portal so the department could have some sort of information about how wholesale transactions are moving within the medical cannabis program. It would also be easier for a business to be able to not have to have large stacks of paperwork that would have to be kept in, sometimes triplicate copy to be able to be presented to the department upon request, and the department will be able to have those as needed. One of the things that how much time do I have left? I don't want to go over my time.
You've gone about 2 minutes over. I'll give you another 15 seconds. I got some,
right,
I'm sure we have questions.
One of the biggest problems with the single cultivation area is that would significantly reduce the ability for for caregivers to grow outdoor cannabis. Outdoor cannabis is a large part of this industry, and it is also the most cost-effective and least environmentally impactful way for cannabis to reach legal patients. I think that we really need to be able to let the businesses decide what is needed for security, business formation, packaging, et cetera. Because as we know, Maine's a large state, and what may work in Portland will not work in Presque Isle. So thank you very much for your time. I'd be happy to answer any questions.
Yeah, no, thanks for coming, Paul. Good to see you. And I know one of the things that you've brought up and we've talked about many times, both in the working group, in the halls of the State House, and conversations we have, is about cost. At the end of the day, cost to the patients, because that's really our focus and our vision and what we should be addressing here. I guess my question has to do with the single cultivation area and how you tied it to indoor. Are you saying, is that because I'm a registered caregiver, I have 30 plants or 500 square feet, I may want to do 250 square feet outdoor and 250 square feet indoor? What's the correlation between the indoor outdoor and the one cultivation?
So the problem is, if you have one cultivation space, is if you're limited on the space that you can cultivate it, you may have one space that'll be better to start seedlings. And then you'll want to be able to move those seedlings from that area to a better cultivation area. And like you said, is that you're going to have to be able to prepare your outdoor plants indoors so they'll be healthy and hardy enough, because I think we're going to have a tough growing season this year before moving them outside. And as a way to ensure that you have a continual supply for your patients, most people will also want to be able to maintain some indoor flowering and some outdoor flowering. So I think there's a way that we can get around that. One of the things I was thinking is just I think you currently have it on your application form right now, you just declare where you're cultivating. And that's something which is so far has seemed to be working, but a single cultivation area would have a big, very detrimental effect. Does that make sense?
I think it does. And Vern can correct me if I'm wrong here. I'm sure he probably will. I think at the end of the day, the intention, probably going to stick my foot in my mouth here. The intention was, I mean, we just want to ensure that the cultivation doesn't happen in two different towns or a mile down the street. So certainly I can understand some of what you're saying and being flexible with, like, it's not just going to be this one room and that's your cultivation area. But is there understanding what we're trying to achieve and get to? Do you think there's workable language for the one cultivation area, but allowing flexibility for exactly what you're talking about?
I mean, I think there is. I just think you're going to have to define, like, maybe a geographic area where there's the cultivation area. But I still need to push back against the idea that there are some people who may be doing outdoor, for example, that may lease a space to do their cultivation that is a mile down the road. And then when the plants are being ready for it to go outside, they'll move them to the greenhouse or they'll move them to the outdoor cultivation area. That is something which, again, maybe can come into the discussion of tracking, even though tracking of plants is a whole other animal that I don't think we want to get into right now. But just the idea that, anytime you're going to limit that cultivation area, it's just going to be putting a burden on the smaller operators. And that is what I do generally believe, that you want to avoid having, unneeded and undue harm to small businesses. But this is something where, speaking as someone who's been doing this for 11 years and talking to a lot of my other, people in the business, is that a single cultivation area will have a huge detriment upon not only the small businesses, but also the patient that access outdoor flower.
Okay. And then I love your suggestion about us developing a trip ticket portal system. I don't know if that would be beyond our resources, large IT projects like that, but it is an interesting suggestion. Vern, do you have any questions for Paul?
Just a couple of sort of points I wanted to make. The single cultivation area is an area is something that's come up as violations that we've identified with caregivers operating really outside the bounds of the program, where they have a full 500 square foot canopy going at one location, and then there's another one going at another town, and they're both mature canopies, and and they're only registering one with us, but also trying to claim both to the different any regulator that might show up. So the other thing I wanted to mention about that cultivation area, the definition in statute talks about an indoor or outdoor area used for cultivation. So we're trying to clarify what we believe the statute already says about a single area being used. Child-resistant packaging, the definition, the part of the definition that you cited is actually, we lifted that from federal regulations about what they use to certify the packaging is child resistant, right? So that's pretty much a national standard as far as packaging is concerned, and anything that you would buy commercially that says that it meets that standard is what we're talking about.
I definitely understand that the packaging point, but I worked very hard on the current statute. And this problem that we're discussing with child safe packaging is not new. This is something that seems to come up every time we have the rules, and it came up almost every year before this went into effect back in 2017. But we specifically put the language in there to not be significantly difficult for a typical adult to open and reseal, is because there are many patients out there who do have grip strength problems. And if they're not able to open that packaging, they have to use scissors or some other device or rely on someone else to get that open. And that is not the intent of the statute when it was passed in 2017. I don't think that's the intent of the department. And as much as I understand you want to go to a national standard, we still are Maine, and we still have the ability to make things work for our citizens before they work for the citizens of California. With the single cultivation area, would it do you think it would be necessary for there to possibly be looking at a statutory change of the word "and" to be able to clarify that it would be within like a geographic area? As something that, there are going to be some medical marijuana bills that are going to be being worked, public hearing and work next week. I know that the committee is going to be very open to hearing from not only the department, but also from stakeholders and patients and other industry people about what can be done to make this program work better. The situation you brought up is obviously an issue. And so I think I think we're going to be able to find a middle ground that makes that work, but we'll just have to look at if the verbiage in the statute needs to change for you guys to feel that you can fulfill your statutory need to make rule.
Yeah, I mean, we'll certainly consider the comment and feedback you gave, understanding what we're trying to achieve and what you're saying, and try to walk that fine line and see if there's a common ground. If at the end of the day, the legislature wants to change the statutory language to change the rule, that's their prerogative. Real quick, Vern, Paul, the language that you have about packaging, where are you finding that? Because I'm not finding it in statute.
So I'm under chapter 558C, 2422 definitions, 1-E, A, and that says, it says 1-E is child resistant, quote, child resistant, unquote, means with respect to packaging or a container, A, specifically designed or constructed to be significantly difficult for a typical child under 5 years of age to open, and to not to be significantly difficult for a typical adult to open
and reseal. Perfect. Thank you.
Thank you.
Thank you. Anything else? I think we're good. Thanks, Paul. Good to see you.
Have a good day, guys. Peace.
You take care. All right. Let me go back. John Arnold, I believe, is being elevated next, which would leave us Mark Barnett, David Valeu, I'm sorry for getting that name wrong, and Jeffrey Nosach. So John Arnold, you are now a panelist.
Hello.
Hey, how are you?
Can you hear me? Wonderful. Yep. All right. So, well, thank you for your time, everybody, today. I mean, I know this is a very important and dear subject to all of us. And I know it's going to be a long day for a lot of us, but I appreciate everybody's time. I'm going to keep this pretty short and sweet. I know we have Mark Barnett coming up, and I hope any extra time that's left over be surrendered to him, because I'm sure he's got a lot of good things to say. But here we are again. It feels like we're discussing the same things we discussed a year ago. The word that comes to mind is regulatory capture. Everything I've learned about regulatory capture is against my will. I see these rule changes as overstepping. Specifically the security measures. The costs that are included with adding these additional requirements to be a compliant business, really affects the small guy. Franklin County isn't the same as Cumberland County. We have a little more space up here. We're able to, kind of self-police because there are no police in our town. Also another issue I'd like to bring up would be the packaging requirements. I mean, we all know the problems that the child safe packaging poses, but what we haven't discussed is the excessive amount of plastic. Will there ever be any changes in the rules to accommodate more of a sustainable manner in which we can continue to do business? Over 300 million in sales. This is not a system that is broken, and feel that these changes will put corporations first and not the people. And it's really sad to see that here in Maine. With that being said, that's all I have to say. Any questions, I'm available. Thank you very much. Oh, I can't hear you guys.
Yeah, no, it's the first time I've done it all day. I left myself on mute. Thank you for being here. Thank you for providing your testimony. Did I hear you say you're located in Franklin County?
Correct.
Okay, and do you have a storefront there?
No, we're not doing a storefront, just because, there's so many things that are, so undecided, and going into a store frontage. And again, the cost associated with it is going to be really difficult for a small company to absorb. And a market might be deemed as a small market. I think again, but with what we contribute as caregivers up here, we contribute to the local economy. Important that we keep up with this tradition, allow people, to keep it small, keep it mom and pop, so we can maintain that Main Street industry that we have here in Maine.
Certainly. And that's one of the loudest messages we heard last time, was making sure that there is a space for the smaller operators. And we certainly made an effort to have that reflect in the rules, but that work continues. So thank you for being
and
here.
I appreciate the work, but the people that you have making some of these rules, might not have our interests. There's a lot of ties to multi-state operators and people that are going into adult use. And I don't think those people are the right people to be helping with the changes or the formation of these rules. If we need to invite more stockholders and more caregivers to this table, and maybe on a county by county basis.
We'll certainly be doing more in the form of stakeholder outreach. So when we're in Franklin County, look for us when we continue that conversation for sure. Vern, did you have any questions for John?
I did not. Just I'd like to thank him for his testimony.
Awesome. Thanks, guys. Keep up the good work. We know it's not an easy job, but keep in mind when you do make these changes.
Thank you for being here. Take care.
Thank you.
All right. Next, we have Mark Barnett, David Vallejo, Jeffrey Nosich, and then Michael Wilson. There we are. Mark, how are you?
Hey there. I'm doing well. How about yourself, Mr. Gunderson?
Good. Thank you for joining us. The floor is yours.
So again, thank you, Director Gunderson, Mr. Malik, and the employees of the OMP. My name is Mark Barnett. I'm a resident of Auburn, registered caregiver, and the owner of a medical retail store in Portland called Higher Grounds. I'm the executive chair of the Maine Craft Cannabis Association. As you might expect, I will be submitting very detailed testimony with over 50 individual, very concrete items. Obviously, I can't go into that level of detail here, but I just want to say, and I know we all have a lot of respect for one another and are doing our best to work together, but we're very disappointed in this draft. And while my colleagues' comments earlier were fairly optimistic, I'm not so sure I share that at this point. Last year's rules, which essentially every participant told you would have killed this program, failed with massive nonpartisan opposition, both in public testimony and in the legislature. And some of the most incredible pieces of that are gone. But this proposal still seems to reflect what I view and many in the community view as an extra statutory agenda. And you'll see that reflected in the specific comments that we have. It's certainly watered down in some ways, but it is still aimed at reducing, in my view, participation in the program, and it will limit access to Maine's amazing medical cannabis products. This agenda is kind of surprising. Medical cannabis is Maine's largest agricultural crop. The cultivation, sale, and processing offers one of the few pathways to the middle class here. It's high quality, affordable medicine, as many of the previous testimonies have referred to. Nearly 100,000 citizens and thousands of patients from across other states flock here for that program. And I want to call something out. Maine's medical cannabis program does not have a documented history of significant problems, public safety, or public health. When the office was asked for such last year, I'm an analyst, I'm a data analyst, there was nothing of merit produced at all. But here we are again with a massive overhaul of how the program functions at its core. Many people view it as sort of a crackdown on a legal market, but there's no justification in data, economics, or health studies. Half of the items in our submission, and again, that's a bit of an estimate because there are a large amount of them, but particularly around cultivation practices, have no origin in statute. They're an interpretation of statute that's rather extreme, and it's against the feedback of the community and that it regulates that we've gotten from the past and that you're going to hear today. And those details are not lost on Maine's small farmers. I mean, people are shocked at this. It seems, and again, respectfully, that the office has adopted a mindset that cannabis is some highly dangerous substance whose commerce should be restricted to the well-funded, politically connected. That couldn't be further away from the reality of what cannabis means to the state. The earlier speaker testified to how different it is to be in Franklin County or Cumberland County. But Maine doesn't need a surveillance state. We don't need demands that we grow in tightly regulated industrial factories. We don't need mandatory testing running our business program. And I would respond to an earlier comment that actually mandatory testing is included in your rule. It's included through the labeling, so it is a little bit tucked away there. But I just wanted to hit these bigger subjects because it seems like we just keep hitting up against this wall over and over again. Why are we going after outdoor cultivation? Why are we bumping up against Fourth Amendment protections? The executive branch sure has some ability to interpret things in its favor or in the way that it would like to, but when it does so against the will of so many of the people that it's regulating, I think we're just hitting a disconnect. And I just want to give everyone a heads up that if you're very frustrated with the rules, thank you for testifying today, but also please submit testimony on some bills that are going to be heard next Monday, particularly LD 1784, which will block the implementation of these rules prior to legislative review.
Mark, yeah.
Yep.
Thank you. For
and I know I'm off the
plug.
subject of the rules, but thanks again for the time.
No, and I will say, I do look forward to your written testimony you provided to us before, and it's incredibly helpful the way that you lay it out for us to make actual consideration of those changes. Vern, do you have any questions for Mark?
No, I was just going to say thank you for your testimony here, and I look forward to your written testimony and the details that I'm sure that will provide us.
Yeah, and as some of our colleagues have, we're happy to do that. That's the way we'd like to proceed. So thank you very much for the opportunity to speak today.
Thanks, Mark. Good to see you. So I think we have Lestat has figured out, I hope he has figured out the audio. So while he gets brought in, I'm going to shut off my camera to quickly use the restroom, but I will be back in about 30 seconds. So I'll hand it over to Vern, and we should have Lestat. And if not, I believe it's David Valeu, Jeffrey Nosach, and Michael Wilson.
All right, Lestat, are you able to join us?
It sounds like I am.
Yes, you are. We can hear you now. Thank you very much.
Can you see me now? Awesome. This is good stuff. So yeah, I just wanted to say, I really appreciated Brett and Greg and Mark's testimony here. Those were all pretty nail on the head. I'll be submitting, for the record, I'm a medical caregiver based out of Wyndham, delivery only, real small, literally just me working. So my rule for rule-based testimony will be written. For now, it's kind of a meta testimony about the issues in this rulemaking process. It's ghastly and just a very thinly veiled attempt at kneecapping a system that works just fine. It's pretty curious that this panel that writes these things up, that the work group that's responsible for this is 7 for 8 adult use people. I mean, that is appalling. And it's like no one's even trying to convince us that this is in good faith. The people here largely believe that cannabis is a human right, and they're not wrong. It was taken away by moneyed interest 80 years ago and sold back to us in such a way that only the rich, only the politically connected get to call the shots. It's really absurd. You're going to start seeing a push for it as a human right. You're going to start seeing the resurgence of massive black market activity, and you're definitely going to see a push for unifying the two under one thing so that the super moneyed interests can't control every aspect of this. I'll be honest, when I saw who was involved in drafting this, it all made perfect sense. And the cronyism is just so apparent. It's so apparent. Like I understand that this is you guys' 9 to 5, right? But the rest of us have to take time out of our day to even take part in the discussion. How does the most robust and best rated system in the nation require 60 pages of new rules? Just how? There's no data. There's no science to what's being suggested here. The people who drafted this see the medical system as their money on the table, as their market share. It all makes way more sense through a bad faith lens. You're not through a good faith lens. It's all very confusing. Like, how did they come to these conclusions? And the rulemaking process is broken. You're not going to get unbroken rules out of a disgustingly broken rulemaking process. Why is it that every time rules are made for the medical system in recent history, that it's by people with tons of money and adult use? There's only one intelligent explanation, unless you're trying to convince everyone and gaslight everyone otherwise. There's a financial incentive to kneecap medical, to take money from the little guy and give it to the big guy who's politically connected. You guys have done very little to allay any concern that this is a pay-for-play system. You know, it's becoming clear that the two-system setup was a mistake, a brutal and onerous mistake.
So, Lestat, I'm going to cut you off.
Connected,
I'm going to cut you off. Typically, I would give you more time, but we haven't really talked about anything that's germane to the rules.
Well, we've talked about the rules in general and how they're formed. I think that's really what a lot of people here take issue with. We have to be on the receiving end of rules and shoot them down. Do you understand? So we're in the position of having to address the greater system. Otherwise, we're fish in a tank. You know, we have to address the rules themselves in a metacognitive sense. And if you refuse to do that, that's pretty telling.
So as far as the working group is concerned, certainly the working group was comprised of a number of registrants, qualifying patients, those that are certifying diversity as far as the stakeholders and how they're built up. As far as those that wrote the rules,
diversity include moneyed adult use?
Okay.
Like,
as far as those that
include,
drafted
like,
the
tons of
rules,
money
that
to
was
adult
the
use?
Office of Marijuana Policy. Just to be clear, that group, we discussed at a high level, filled in an information deficit, and really set our pathway as far as how we wanted to approach these rules. But OMP staff is the one that—
Information deficit sounds like you had them writing it.
Vern, do you have any questions for Lestat?
No, I'm all set. Thank you very much.
All right. Thank you.
You guys are complicit in market manipulation.
Okay. So next is David Vallejo, and again, apologize if I'm not getting that right. Jeffrey Nosich and Michael Wilson.
Good morning.
Hey, welcome.
It's Vayu.
Vayu, God.
You're good. You're good.
Thank you.
So
Sorry.
good morning. Thank you for giving me a couple minutes. I am a small caregiver operating out of Western Maine in New Portland. I just wanted to touch base on a couple things that I think are specifically impactful to me, but I think that obviously will probably translate to other people that are similar to my situation. We run and operate a really small business. It's me and my wife is one of basically my registered employees, and we have one part-time helper who helps us do things when necessary. But essentially, we are doing everything that we can, obviously, to stay within the program's rules and regulations and all the legislation as it comes. The biggest thing for me right now going through the rules is looking at specifically with our small retail store, caregiver store. We built it because we assumed that we would have to have a better way to get product, obviously, to patients without having them come to my home or grow operation, which potentially is obviously like not a safe situation sometimes when you're dealing with people you don't know. 6 months later, we changed it to be able to do wholesale. So for me now, I've gone ahead and I've installed chains, and you can't actually get into the property unless we're there. We have adequate lighting, and I also have a home-based, well, not home-based, but like a aftermarket or a smaller security system that is motion activated. For me to go and have to actually employ a service provider to do that would be so cost prohibitive that it's actually going to increase cost to patients, which is obviously something we're trying to avoid. I just don't think it's necessary. Where we're located, you're not essentially going to have a quick response because we don't have a police force out here. So to have a sheriff or a state trooper eventually get to my business if there is a break-in or something like that, the information that I log when anything like that or there's any movement or activity is going to be the same as if a security company is obviously monitoring that all the time, as well as an alarm system. By the time someone gets there after an alarm goes off, the damage has already been done. The biggest thing also for me is because I'm small, I have property that we use to grow in a greenhouse, but we also have a small building that is within a half a mile of each other. But if we were to be limited to one specific location, it would definitely cause issues because I don't have the space at either one place to do both. And I definitely understand that we need to make sure that people are giving OMP adequate information as to where things are being grown, how things are being cultivated, where processes are happening. I totally understand that, and I think that that's okay. I just think that we need to make sure that in the wording, we are not creating hardships and speed bumps, if you will, for small people like myself to continue being profitable enough to continue being a viable business that supports a small family. I definitely do not think that the tracking that is essentially metric without being metric is going to be beneficial. I feel like it will be super cumbersome and essentially cost prohibitive for me, which is obviously going to add cost as well. And I'll keep it brief. I think that what I really would like to do is just implore the people on the board to recognize that for a lot of years, small caregivers were the ones that paid taxes and the people that were doing the right things and making sure that they were renewing their licensing and their applications, essentially help build the branch that is become OMP. And that if we don't make sure that legislation is smart and relevant to everyone, from small growers to medium to the big businesses that are coming in, we're essentially going to throw the baby out with the bathwater. And it would be a little bit unethical and immoral to kind of turn our backs on thousands of Mainers who are essentially the backbone of arguably the best medical program in the nation. And that's really, I will definitely be submitting some more detailed information via email. But those are quickly some of the biggest things for me, is just making sure that we're not allowing big business to help push regulation that is effectively making staying within the industry cost prohibitive to those of us that have helped build it and done the right things, even at our own expense, or in a situation where it's become harder for us to do things, but we still maintain and persevere, if you will.
Yeah, no, David, thank you for the testimony, and we'll look forward to the written testimony. I do have a question for you, though. As far as the one location, one cultivation location, you said you have two different locations when you are cultivating. Are you able to just give us a little bit more detail of how you utilize those two locations?
Of course. So my actual grow space, my indoor space, is very small. So I am licensed for 500 canopy, but I only actually utilize about 250 in my indoor space. And then my greenhouse I only usually have about 200 square feet of plants in there at any one given time. So I'm under my capacity. And like I said, the properties that I'm talking about are both owned by my wife and I, and they're legit like across the road from each other on our little dirt road in Western Maine. The biggest thing is that I don't have a space to do those things safely outside at the place where my indoor facility is. So if we were to say you have to basically grow in one location, I essentially, like someone said before, I have to go find financing and build a new building, which is not that easy to do.
Yeah. No, that's perfect. Thank you for the clarity. And as far as the tracking is concerned and the requirements that we lay out in the proposed rule, as far as all the things that would need to be tracked, whether you have your own system or business records or Excel spreadsheet, are there certain things that right now, as far as your business, in your operations and in your own records, that you are currently keeping that would not be, I think, as you said, an additional burden?
I think the biggest thing is I definitely have a point of sale system. Obviously, we want to track our inventory. We want to make sure that we know what we have. I think the biggest thing is when you start mandating that, like, let's say, even if it were to just be like every month or every 6 months, when you start coercing people into giving you extra information in terms of, like, I had 10 clones that look like they may have not been super strong, so we threw them away, to have like a constant record of everything, weighing stock, stems, all those things. For anyone that's like me, that's essentially doing 98% of all of the business aspects, so all of the administration stuff, as well as the growing aspect, I don't have 5 more hours in a day. You know what I mean? And so that's really what it comes down to is I don't think that it's a problem that we have transparency, insight into the day-to-day operations and flower inventory and sales and stuff like that. I think the problem becomes when we start making rules that force people to add more time to their day to ensure that the state is getting information that really might not even necessarily be that pertinent if we start looking at sales and other things that are already being tracked.
Thank you for that clarity.
For sure. Thank you.
Appreciate it. Vern, did you have any questions for David?
I did not, but thank you very much. It's helpful to hear from you.
Yeah, it is. Thank you. We'll certainly consider the written testimony. So thank you.
Awesome. Thanks, guys.
Yeah, take care.
Bye-bye.
All right. Jeffrey, Michael Wilson, Derek Shirley, and then Catherine Lewis. Jeffrey. Oh, there we are.
Hello.
Hey, how are you?
Good. How's it going?
Good. Welcome. The floor is yours, please.
Thank you very much. I appreciate the opportunity. There was a lot of things in the rules that really don't cause a problem, and that's fine. And we do appreciate that the rules need to be updated and brought up to statute. And I think one of the main takeaways after watching all these testimonies, I have all these things written down that kind of have already been gone over. So I think the main takeaway is that you want to update to statute what the statutory requirements are. All of us want to have that. Obviously, we want the state to be in line with what the legislator deems is appropriate. So I think starting this process from just that standpoint and not adding any additional things to the rules that currently aren't broken. If we have something in the current rules that are broken and are, don't need to be brought up to statute, maybe we should deal with those. But I think a lot of people's frustrations, and it's coming out pretty strong with some people, obviously, and a lot of the people that aren't going to testify, I'm sure, have very strong frustrations, is partly because there's so many additional things in addition to the things that need to bring us up to statute. Let's just get to the statutory place and then start talking about whether or not we need track and trace. We don't even know if we need it. We certainly don't need a company like Metric to control it. There may be some really great ways to do track and trace. For example, MOFGA already tracks and traces all of our organic hemp. They do an incredible job. We have a sit down, we go through all these details, and they really want to provide accountability to the customer who would end up buying it and knowing where the batches are coming from. And that's the whole point of track and traces. So people who buy it know what they're getting and know that it's real. So looking towards someone like MOFGA rather than this very troublesome company that everybody hates named Metric is definitely a good way to gain trust. But also just not breaching that necessity to come into line with the statutory requirements, I think is a great way to start this off. And then let's take all that other stuff that maybe certain people in the industry want to see updated. Let's deal with that differently. And maybe after we get up to date so that it feels like all this stuff is so rushed because we really need to get up to date, but we can just drop all that other stuff, get up to date, and then start working on a process. I think that's my main takeaway and what I really wanted to say.
Yeah, no, thank you for joining us. I do have some questions for you.
I would like to say if I have another second too,
yeah, you do.
If that's okay, I'll be really quick. I'm exclusively outdoor producer. So the 2 spaces and that kind of thing, I do have a lot to say about that. I grow hemp in a different town. I would like to possibly do an autoflower crop on that field potentially someday because the soil's great. And that's not going to stop me from my full-term crop that happens outdoors. I could potentially bring in 2 crops, but they definitely have to be growing at the same time. They won't be flowering at the same time, but they will be in 2 different spaces and at the same, summer. I have just the summer. And just that being said, I think outdoor growers, people who choose to grow exclusively outdoor, which is much lower on the environment, et cetera, should be given a little bit more flexibility with how many plants they get to grow and stuff like that. Because we get 1 chance per year. We don't have the whole winter to flower and all that stuff. So maybe a little more flexibility. That's the last thing I have to say.
Certainly, the flexibility with plant count and square footage is not in OMP's power. That's statutorily set, but I certainly hear you.
I understand.
Also, a point of clarity. There's no metric proposal within this rule. And then as far as rules are concerned, I hear you what you're saying about getting us up to line with statute, but rules are really an opportunity for the regulatory agency to be able to interpret some vague language so there's a shared understanding between registrants and the agency as well. But I guess my two questions are, one, you said there's some things that are in the rule that are okay and you understand. I wonder if you could highlight one or two of those so we can understand where we have struck a good chord. And then also just a little bit more information about the MOFCA tracking.
Okay, sure. I had some bullet points. One of them, the first one, is that I support requiring products to disclose whether or not they are tested and who produced them. So okay. I do like the goal and the aim of testing and tracking, but I don't think any state has ever done it right. Just trying to get the consumer with the goal of having the consumer know what they have. We start from that point and then move backwards into like, how do we do it? Not like, oh, this is how other places did it. That must work. We don't even know if that works, but disclosing that requirement on the thing that says yes or no, it is tested or it isn't tested. That's super critical. Definitely should be in the rule.
Okay. Can you give us a little bit of detail around the MOFCA tracking and what kind of the parameters are for that?
Sure. Their goal at MOFCA is to make sure there's not diversion in terms of like, because they want it, if you have strawberries and they're organic, they want to make sure you don't have non-organic strawberries in your organic strawberries and are selling them at that higher price, which if you think about it is exactly what you're trying to do. You're trying to make sure that not cultivated by this person and tested to be this product ends up in that package. Or, I would think that would be a goal, other than, I don't think you're trying to make it just overly burdensome. I have no reason to believe that. But if that's the goal, those are the kind of things they try to do. And so they have you, keep batches, and then you keep the records of the sales of those batches, and all that stuff can be gone back through and look at like, okay, you said you grew this much, you have to submit field reports, you have to submit the batch reports, and then, they are able to then track back through all the records that you have to say like, why did you sell this many strawberries if you only grew these rows? And in every other year in the past, you've reported that you had 100 pounds on each row, but you sold 10,000 pounds of strawberries. Like where's the difference? So that's their whole point. And there's so many experts over there that could explain that to you. Or somebody, maybe a working group could invite someone over there to try to, it's incredibly detailed process. It's a lot of work for us. And it actually really hits at the point of what you're trying to do, I think.
Does MOFCA have like a MOFCA portal for that reporting, or do you report it via Excel spreadsheet, or like how do you actually?
There is a bunch of paperwork like field notes and reports. There's not necessarily a spreadsheet, and all that paperwork gets submitted. And then there's an auditor that comes to the farm and goes over it all. And kind of if there's clarity that needs to be made, they just make sure they go through. It's kind of like your inspection process, but it's a little bit more like focused, like let's see the documents, let's go over them and backtrack through your crop.
Got it. Thank you. Vern, do you have any questions for Jeffrey?
No, I didn't, but I do want to thank you for educating us on the MOFCA piece. It's really helpful to hear about those things. We love taking that info in.
Yeah, great. Thank you.
Hey, thanks for being here today. We appreciate it.
Yep, take care.
All right, so the next three, I believe Michael Wilson will be elevated. Then we have Derek Shirley, Catherine Lewis, and Eric Sprague. There we are. I think you're still on mute.
All right, can you hear me okay?
Yeah, hey, how you doing?
All right, name's Mike Wilson. I live in Portland, Maine. My company is Maine Craft Cannabis. We're a cultivator. So I wanted to say thanks, first of all, because, I did see that in the rules that you guys did address some stuff and there are some changes. to show that you guys have addressed some of the concerns that have come up. Me personally, I'm still really disappointed in the amount of, burdensome, basically documentation, and what I see as things that don't really provide value. I have a list that I'm going to go through, and I'm going to come back in more detail and cover them in a little more detail, and then close up. So I'm going to go through, I know you guys wanted like actual sections to reference, so I made a lot of notes here. I'm going to try to blast through them pretty quick and then just go back to the ones I really feel most strongly about. 5.1.1b, I think that needs to be clarified. And this one might be in statute. It might be a statute problem. I'm not sure. But for someone who has 500 square feet of flower, they might have 100 plants. And right now it says 60 immature plants. So the number of veg plants, I think it should be double the number of flowering plants that somebody says that they want to cover. And that might be in statute. I'm not sure. 5.1.1-N, that's the business entity type. That's sort of connected to one of the other ones. I'll come back to that one later, but I think that section should be removed. 5.2.1-C, I think that you need to clarify that. The language says for no disqualifying drug offenses, it just says such offenses. I think that that's too vague. I just don't understand what that means. So I think there's some clarity around that. 5.3.2, I think you should revise that one, basically the whole section. I think that, I'm not going to go into detail on this one, to say really quickly, I think it just creates a higher barrier to entry for small people. I think people that are established, this is pretty reasonable stuff and people can do it. But in general, I think it creates a higher barrier to entry and just makes things more complicated to do business. And I don't think it really provides value to consumers. And I'm not even sure it really provides value to you guys. So I really want to question that one. 5.3.2-A specifically, again, it basically is connected to 6.2.2, which is the entity type. Okay, 6.1.1-E. This sounds like it would make me responsible for others' conduct, such as if a contractor that I had hired to come in and do some work did something that I didn't like, even though I instructed him not to, I would be responsible for that. And I don't understand what the extent of that would be. So I think that should be removed and just kind of covered by basic law, instead of making it explicit that I'm responsible for a contractor that I've hired who I don't really have control over. 6.1.2-B, I think you should remove that. A lot of people have talked about that. I find this one really upsetting. It's entirely new. I don't understand why you would have added it. It almost like slipped in underneath the radar. A lot of people have hit on why it's difficult. I think that Vern mentioned that there was a reason that came up because people were kind of juggling stuff. I think there's a much better way to address that. Just ask people to state if they have multiple locations, where they are and what they do in those locations. But I think there's a lot of logistical reasons that people do some things in one place and some things in another place. And I understand that you guys want to know where that is. But requiring one cultivation space it's not required by statute. And I don't understand how it provides the value against the burden that it would create. 6.1.3. I'll make it quick. I know it's already going past time. I think that section, I actually have a lot of those things in my facility, but I didn't when I was small. So I think that that is something that people should be able to self-regulate all of those requirements. And I understand most of that doesn't apply to cultivation. But again, I think that it should just be something that people can control themselves. Also, the video motion requirement for the 120 seconds. I don't think my system does that, and I'm not sure a lot do. So I think addressing the time requirement for the pre and post motion sensor, I think is relevant to what's available on the market. It requires 120 seconds pre and post motion. And I have a system, I don't think I could select that. 6.2.2.B, that's the entity type. I have a real problem with this one. Statute 22-2423-A specifically authorizes caregivers to be authorized in any type of legal business entity recognized under the laws of the state. And that includes entity types that we chose at the time that we were forming our business entity with a lawyer. And this would basically, provide a whole bunch of hurdles for my wife and I to separate our businesses. And I don't see how it provides any value to you guys, to patients. I just think it's a lot of rigmarole we'd be the same thing. It would just be a whole bunch of paperwork for us, and it doesn't provide any value, and statute specifically allows us to be what we currently are. Maybe I misunderstand that, but 6.2.2-B, I think you should remove that. I don't understand what sole control means. I think it's too vague. 7.2.2, that's the record keeping thing. People have really talked about that a lot. It's basically metric without requiring metric. It would almost be easier to do metric than to do this. This is so burdensome to anybody who's smaller to record all of this information on a daily basis. I don't think it gives you guys what you guys want either. And that is that anybody who's seeking to evade you guys or divert stuff is just going to forge their records anyway. And people who are doing it right and keeping all the records are just doing a whole bunch of extra paperwork, and it doesn't provide value. My background is as an engineer, and doing extra things as a business just makes you less efficient. And it basically, you're creating a whole inefficiency in the medical market that doesn't provide value. The trip tickets and the direct travel, I'll address those together, 7.3.2 and 7.3.3. The direct travel thing doesn't really make a lot of sense. If you had a large amount, I think that you should have a trip ticket. If I'm delivering a ½ ounce to a patient, trip ticket sort of doesn't really even make sense. It's under the legal limit to possess anyway. And then for the direct travel, to do our deliveries to our vendors, we'd have to basically do like a suicide run from our cultivation facility to deliver to all of our people in the state. So that is what currently takes us an afternoon would take days to do. And again, I don't think it provides any value. I know I'm over my time. I'll just run through the last ones real quick. 8.1.1-C. I think you should remove that, the deli style sales. It would be my response. I think that their responsibility needs to be in the store at that point. Once I transfer the product to the store, that sounds like I would still be responsible even after it's been transferred from my possession to a deli style store. The child-proof thing in 8.1, I think that should only apply to non-flour products. I do have patients that have trouble opening our jars who are older folks, and flour is not inherently dangerous, like edibles and tinctures and things like that. Yeah, if a kid gets into that. But if a kid opens a jar of flour, they're not gonna, it's all THCA. I think you guys understand that. It's not actually dangerous at that point unless someone basically ignites it and inhales it. So for flour jars, I think there should be an option to remove the child-proof thing. I got two more. 8.1.2, I think you should revise that. Exit packaging. That should only apply to transfers done in storefronts. I don't think that should apply if I'm meeting a patient, one of my direct sales, to have exit packaging around my other packaging. And then the last one is section 10 on waste. I think that you need more definition on what waste is. Like my question was, does it apply to root balls and just regular water leaves, which have no THC in them? And that's it. I'm not going to go back and revise anything in more detail. I think I covered it.
Yeah, what I'm hoping is, I mean, you can see I start taking it. Well, you can't see it, but
I will provide.
I stopped because you were going so quick. You're going to have written testimony. Good. Yeah, some of the early ones again were statutory language, and really our approach to a lot of these rules were to where we were able and we didn't need clarity to leave it at the statutory language, understanding any meat we add to the bone will get a significant amount of attention. But certainly some of the things that you mentioned, we can circle back and consider with your written testimony when we go through that process over the next couple of weeks. So,
okay, I have one other thing to add, if I may. Is that okay?
Yeah, fire away.
All right. These are some closing things I wanted to say. I know I went way over time. My thought on all of this is, as you know, having been an engineer my whole life, there's an obligation as a producer of something to look at lessons learned. And I think that Maine has an opportunity to look at lessons learned in other states and look at what policy has done and how it's worked out in those states. We can go through all the examples here, but I feel like that's not being done. And Maine has an opportunity to really get it right for people. And, I think that the people in the legislature are really saying one thing, and what we've seen coming out of OMP is really something else. And the intent of all of this, I think, is that what we are doing is trying to basically compete against these different markets. You have the black market, you have the medical market, and the adult use market. And the closer that the medical and adult use can come in price and quality to the illicit market, the more people are just going to move that way. So I understand you need to regulate it, but from a thought process, anytime you make us do something that doesn't add value and doesn't give you guys value, I think you need to not put it in there. And I see a lot of stuff in here that I don't think is going to give you what you want, and I don't think it provides value to the patients. So part of it is I don't want to have to do a bunch of extra legwork, but also it's having worked in companies, and especially smaller companies, I've seen them fail. I've worked for companies that have gone out of business because they just do too much crap that doesn't add value. So that's my closing argument, and that's really the high level intent of it, what I think you guys should be doing with your rules, because you're dictating to a whole industry what we have to do to stay in business and put product on the market. Thank you for your time.
Yeah, absolutely. Vern, do you have any questions for Michael?
I guess I would just have one, and that's around, what is it that you do track right now for your inventory? If I asked you hypothetically, how many mature plants do you have? Could you tell me? If I said, how many pounds of flour do you have? Could you tell me that?
And I couldn't tell you on the spot the number of plants for sure. I mean, I have like a schedule and a production log. It might not be exact, but I could tell you in pretty good planning what I have right now, what I'm planning to have next month. My business is probably a little more complicated than, like, a year ago, I didn't know that stuff. And 2 years ago, so part of the reason that it's difficult for me to agree with any tracking of the number of plants in going through different stages is, if you just say the number of plants, that's one thing, but the number of transactions of when I throw stuff away, it's so different for different business sizes. So to answer your question, for tracking, finished product is really when we start to know what we have. What's in process is really, there's a flow to it. And it'd be really difficult to track that on a daily basis, even at my scale, and someone who's smaller. It's just logistically, it's just a nightmare. Once we have finished product, like if you ask me how many chocolate bars I have in stock right now, I couldn't tell you right now, but we have a board where we keep that stuff on a, it's like a little eraser board. So finished product, we have a pretty good idea of what we have, but until then, there's a flow to it. But I do have like schedules for how many different plants we have at different sizes.
Sure. I guess there's just one thing I would clarify from, our expectations when we drafted the tracking section. Our expectation isn't that at the end of every day you'll have an inventory and that you have to go around and count the plants and the growth phase, things like that. It's more that when things change, you make the adjustment. So, when you move plants from immature to mature, that there's growth cycles, there's lights, lighting that changes. Sometimes people move to a different room. Those are the things that get reported or tracked by you, not even reported to us, but tracked by you and maintained by you. So we were trying to be conscientious of not adding extra burden, but under thinking that most caregivers would know how many plants they have, would know how much flour they have, and would know what they're selling and things like that. We're not trying to make it more burdensome, but we think what we're asking for, which is why it's good to hear from folks like you, we think that what we're trying to get at is really the kind of thing that most business people know anyway as part of doing business. So I do appreciate you taking the time, and we do look forward to your written testimony because, gosh, there's an awful lot in there, and it's helpful for us to hear from you. So thank you.
Thank you, guys.
Yeah, take care. Thank you so much. Okay, Derek Shirley, Catherine Lewis, Eric Sprague, and then Asher Putterman. All right, Derek, you're a panelist. You should be able to unmute and come on camera.
Hi, guys.
Welcome.
How you guys doing?
Good. Yourself?
I can't complain. I'm in a good mood. I'm medicated, so you'll have happy me today. So don't worry. So I actually wrote something this time, so it's not just jabber. I got ready. So my name is Derek Shirley. I live in Gray, Maine. I'm a patient, a podcast host, a proud felon for 4 ounces of cannabis, and a board member of the Maine Cannabis Coalition. The first day, and one thing I just want to point out right before you said, Eric Gunderson, you said the OMP work group helped guide the rules, right? We're clear on that? Okay. The first day, the OMP medical work group, first thing they addressed or discussed were some people would complain about the work group participants, which struck me as odd. They would even bring that up. And then it got me into looking at the details on who was actually in the medical work group. And it came to my attention almost immediately. Not one, but 5 out of the 6 caregivers represented have adult use ties, whether it's conditional licenses, actual businesses, or helped with legalized Maine. I look further down and I see dispensaries represented, and I see again 2 dispensaries licenses with adult use ties. Not just that, but one has created the first cannabis billionaire with a B. Meanwhile, there's 40,000 people still in jail for cannabis-related charges. Seriously, think about that for 1 second as we're discussing these rules. What about those 40,000 people? How can our laws, and we change them, can help that? Remember, it takes about 11 days to count to 1 million, about 30 years to count to 1 billion. Their MSOs, multi-state operators, are a whole other universe when it comes, and their only objective is to take over cannabis markets across not just the country, but the entire world. How will you protect local businesses from a billionaire behemoth is the question you should be asking when you are rewriting these rules, if you truly care about small businesses. For the cherry on top, I looked and I see only 3 patient representatives for 100,000 people that patients, only 3 slots. I thought this was a medical work group. Is this a joke? Where's Ashton Kutcher? Am I getting punked? And then the Maine voters were told in 2016 that the adult use would have 0 effect on medical change. A high chunk of the people in the medical program knew that was a lie. But a solid percent of people voted AU based off the fact that it wouldn't affect medical. Fast forward 6 years later, you have adult use ties all over this medical work group, and they are influencing medical rules. How does that not fall under affected? So for your 59 pages, it wasn't 60. Whoever said 60, it wasn't 60. It was 59 rules. In my opinion, complete hullabaloo, complete taboo, complete garbage. The lack of representation across the board. And here are examples of rules, of OMP rules that showed misrepresentation. And I can list them. I have 2, and I figured I'll come this close to my time. So would you like to hear some of my issues real quick?
Well, you're out of time, but we have been fairly lenient. If you actually talk about the rules itself, yes, I will give you.
Absolutely. I have 2 points because, like you said, they help guide the rules in the beginning. So it does pertain, absolutely, because it helped guide the rules. We're talking about the rules, no?
Yeah.
No?
Oh, Mr. Shirley, did you have anything that you wanted to add about the rules?
Yeah, so section 11.1.2, patient access. You're screwing us, per usual. 7.2.7, again, metric. Do you think we can't read? Like, I think the only thing you guys heard when we said, oh, these rules were a lot was, they were complaining it was 83 pages. Let's just reword it and make it 89 or 59, excuse me. So I'm not mad right now. I'm getting a little testy. I apologize. I don't mean anything personal, Vern and Eric. We're all homies here. We all want cannabis. But at the same time, guys, let's be real. There's a cannabis billionaire. How are you protecting your local businesses? How? And that's what you should be thinking, not just inviting them in to have influence to these rules. And that's why that work group is actually part of this conversation, because like you said in the beginning, it helped guide the rules, and that's why we're here. Right? Thank you.
Thank you, Mr. Shirley. Derek, good to see you again. I'm glad we got the happy Derek.
Show sometime. I'd love to have you on my show. It's hard to reach you. We'll be friendly. You can meet my kid. He's a wonderful boy. I'm serious.
Yeah, I heard that. Congratulations. And I'm glad that we did get happy Derek. Vern, do you have any questions?
See, you like my background? I don't know if you got rumors, but I got a new background for you.
There's been quite a few plugs today. We'll let it slide.
Right, but hey, more than welcome to come on, Eric. One to have you.
All right.
You too, Vern. You seem cool.
Take care, Derek.
Thank you, Derek.
Always fun when Derek. All right. Catherine Lewis, Eric Sprague, Asher Putterman, and then after we elevate Catherine, Dave Vickers. Catherine, you are a panelist. Welcome.
Hello.
Hey.
Oops, I can't get this started here. Sorry. Stop clicking. Okay, we got it. Sorry about that. Good morning.
Morning.
My name is Catherine Lewis. I am a caregiver, a storefront owner, the chair of Medical Marijuana Caregivers of Maine Trade Association, and a member of the Cannabis Council of Maine, which was a group of leaders of the 4 largest caregiver groups come together. I also was a participant in the work group just discussed by Mr. Shirley. That was hosted by OMP, and I was grateful to be able to participate. I also want to be very clear that the work group did not come up with these rules at all. We didn't see them until everyone else did. We didn't discuss them. We talked high level. The problem that most people have right now, and the reason why this keeps coming up, is because the Portland Press Herald made a title that the caregiver work group put together the rules. So that's where a lot of this is coming from. I actually spoke to them and had them change that. So that just took up a minute of my time, but I just wanted to make that very, very clear that we did not see these rules, nor did we make them. At this time, even participating, I'm still against this version of rules. I'm hopeful, though, that we can start here and work forward. I went down line item by line item with extensive concerns that we need to address. I'm going to hit some of them, and again, you'll get that in writing. And I'm sorry if I'm over speaking on what other people have already said. So we had like 5.8. This could result in further delay in processing applications that we currently are experiencing issues receiving our cards in a timely fashion. And I think that this is going to make it tougher. I know that the rules, the way that the application process is now online is meant to be better. It's worse. The fact that we cannot do our one payment for everything that you need right up front online is a huge concern. And I believe that the online application process should be taken down until the online money transfer is allowed, because mistakes are being made that could be prevented otherwise. We have 6.1.2. It's not in statute. It's requiring a visitor log. It's not really pertinent to what we do here. 6.1.3D is patient privacy issues, video during inspection. There is no reason for anyone from the department to watch our videos unless we're under investigation or unless we've reported a crime that we need to present to the department. There is no reason for an inspector to look at that. Patient privacy, huge. 6.1.1, obviously there's record keeping that the department needs to see, but when it says to present on demand, I believe a time limit should be set on that because it would completely interrupt our business to try to pull together all the different records. I have records at my desk, one of my secretary's desk, my compliance person's desk. So to pull everything together without notice would be difficult. 5.3.2A shouldn't even be a concern. Businesses by statute are not allowed to apply as caregivers. There should only be on the application the request for the social security number of the individual that is applying. Do not ask for the federal ID number, and then you're not going to have issues with the business information that the department needs to verify. So the social security number and then the sales tax number that is now on there obviously is a huge help to show that the caregivers are paying their taxes. Section 1 under admin, 1.1 inspect business records and any vehicle used to transport. Again, if we were under investigation, that might be reasonable, but there's no reason for this for the department to inspect our vehicles whatsoever. It translates more to the department managing my business, and that's my job. 6.2.2 is not in statute and not necessary. 6.2 6.2.4, the one location, the one thing that I have to say about that is we grow cultivating at a farm in our greenhouses, and then we bring it back to the shop to trim and process. So under your definition, that would not be allowed. So I'm going to be trimming and processing outside at my greenhouse. It doesn't work that way. So we need that fixed. 6.2.8 prohibited conduct, number C -2, the no drive-through. That doesn't make sense. Why wouldn't we, during COVID, we were doing curbside delivery. Why wouldn't we if you have the ability to do drive-through, why not? You can verify the cards and you can pass out whatever the person wants, and you're reducing the effect, the risk factor for both the patient and the caregiver. So that's not in statute, and that doesn't make sense to me why it would be there. Also in the same section, line D, it's if you have a storefront, you're able to sell plants. Why would a regular caregiver operating out of their home not be able to sell their plants to a patient as well? I think that needs to be removed. Section F, there are already facilities that have dual use, that in the same building, there is an adult use business and a medical business, but here in rural, it would eliminate that. So there's people that already have invested in that. Section H is also not necessary. That is not allowing the patient to open the packaging when they come into the store. I have patients that come in that have MS, that have cerebral palsy, various conditions, and we come in to do a consult. They have their card, they need to replenish, and they can't even talk. They can't vocalize unless they consume something like vaporizing or an edible, a tincture, and it might take them 5 or 10 minutes to get so that they can actually sit and talk to me. So for them not to be allowed to come into their caregiver's place of business, purchase what they need, use some, and then have their consultation doesn't make sense. We're in this to help these patients. And if somebody is having an issue, we're going to help them. And we're allowed to assist them by statute with procuring it, but also with their use. So I've literally had to pass somebody a vape pen and hold it in their mouth because they can't stop shaking enough to actually have a conversation. So these are just a few of them. I have no idea where I'm at with, I'm out of time, I'm sorry. And I have 5 pages of them, so.
Yeah, well, we've been flexible. Yeah, we've been flexible, and it's helpful the way that you're presenting it. I know you'll get us the written testimony, so that's helpful. So just, I got notes for what you went through. 2 things: the sale of plants for stores and not any other registrant in the program is statutory. It doesn't. I can understand why it seemed like it wouldn't make sense, but it's statutory. And then as far as the credit card processing is something that we've heard for a while. And that comes down to for OMP to be able to accept credit card payments. It's something that we've certainly heard for a while. And we've struggled with because we obviously have banking relationships and contracts, and we have some of the same prohibitions that those in the industry would have with that. I will say, after about 1.5 years of work on that, we do have some exciting news coming down the pike.
Good, because the banks are accepting your money anyway. That is coming from us. So online versus in a paper check, again.
I'm not a federal or state bank regulator. They tell us what we can and can't do, and I tend not to question.
Question everything, yeah. Question.
So Vern, I'm sorry, I almost forgot. Vern, do you have any questions for Catherine?
No, just a comment, Catherine. Nobody would like to process credit cards more than OMP. It would be a tremendous benefit to our staff, and convenience is not just on your end, it's on our end as well. So we feel that pain, and we wish we could too. And I did want to thank you. I appreciate the feedback you've given us over the last few months about the online application process. Just want to let you know we hear what you're saying. We appreciate the feedback. We take it to heart, and we've tried to make the changes and acknowledge that we could have done better on the rollout of it. Appreciate everybody's patience with us. And in the end, I think it will be a better solution than what we've been experiencing. The one payment with the background check and the license fee or registration fee, we made that change just to explain it to everybody because it comes up a lot. If you send us a $1,500 check and we deposit it for your canopy, and then we find that you have a criminal conviction that you thought was long enough ago that it shouldn't count, but it really does by statute, we can't give you back your $1,500. And it happens more often than you'd think. And that's the reason why we said we don't really want your money until we're sure we can approve this. So there is a method to the madness behind the scenes. Just wanted to acknowledge your comments there and thank you for continuing to give us that feedback.
Maybe an option would be that people that have a concern that could affect, they would be allowed to do like a paper copy and do it up separately. But I've found that on some of my own personal applications, the background check money gets in and then they're not finding the actual check that we're sending in, or it's got applied to a different caregiver's application. So the paper with the electronic, it really isn't working well. And it can't be good for your people to be getting calls from angry caregivers going, what do you mean you don't have my check?
Yeah.
It's been sent.
Certain,
so maybe
certain
there's
changes,
another option.
Certain changes coming, and we did have a spell there where we were receiving those second checks that had no identifying information on them, which obviously makes it fairly complicated. But we will get there, and we've heard your feedback and others. So hopefully,
thank you.
At the end of the day, we get to where it's easier for both us and you. So thank you. Good to see you again, Catherine.
Thank you.
Take care. All right. So we're going Asher Putterman, I believe, is being elevated next. Dave Vickers, Christopher Gudmundson, and CJ Hagan. So I believe, Asher, you have been elevated. There he is. How are you?
Doing well. How are you guys doing?
Good, good. Good to see you.
All right. Try and make this as quick as possible. My name is Asher Putterman. I'm a medical patient and caregiver, member of the Craft Cannabis Association, Seed to Health Orny Alliance, Maine Cannabis Coalition, and Medical Marijuana Caregivers of Maine. My wife and I operate a small farm in the mid-coast. We grow cut flowers and veggies, as well as a couple annual crops of sun-grown cannabis. Every winter, we've defended our right to have these businesses, and alongside with the legislature, we've addressed any community concerns, and we've together developed a working structure of statutes and rules that protect the public while setting up a regulatory structure that has also allowed these businesses to grow. Over the last couple of years, we've all been watched as big money and overregulation has crept into our state, as well as others like California and Colorado, places that were synonymous with this industry. We've watched many small farms in these states go under due to overregulation, something we have avoided here in this state. Now with adult use being initiated, we seem to be facing similar issues within our regulators in regards to corporate capture, whether realized or not. Suddenly, we are fighting against a more aggressive attempt to overregulate and limit this market. Every winter now, OMP has proposed a version of roughly the same problematic rules that will cause many of the problems we see in other states. Luckily, we can look to these other states and see the future. In California in 2021, they had to bail out their struggling legal cannabis industry to the tune of $100 million, while small farms and small farmers organized protests and filed lawsuits against the state, as well as their track and trace system of metric. We all even heard proof of this happening in our state. The recent adult use testimony, where many adult use program participants were heard complaining about all the added costs, labor, time, and trash created by these track and trace programs that in actuality do nothing to prevent diversion and are simply an added cost to those doing honest business. Now, as the cannabis markets are maturing and everyone is getting their production dialed in, we also find ourselves in a flooded market. Prices are dropping. Everyone we know's businesses are a little slower this year. But this is expected, and prices should fall as supply increases. This is also beneficial to Maine's medical use patients. We should not instead use overregulation to falsely inflate the market price. It will only push out the small businesses. And as we can see in other states, as soon as that happens, the big businesses that can afford to wait out this destruction will simply shift their lobbying efforts to reversing these regulations while locking out all their competition from re-entering the market. This is the corporate playbook being used in every state. Instead, I think we should be figuring out what the future looks like for all these small businesses, or what is even the scale of most of these businesses. We've been inspected and required to have a sales tax ID number for years now. So why don't we have any data on the average size of businesses in this market? Why don't we get an annual report that's on time? How are Maine businesses going to survive when we see national legislation go through and we're suddenly in competition with farms in far more favorable growing conditions? As a market, we're going through some growing pains right now. For the first time, we do not expect to make more money this year than last year on cannabis. Instead, we are having to scramble to figure out how to survive. We're having to invest in our business while income is falling and while simultaneously still being blocked from any financial institutions or abilities to borrow capital. All I see here is more added expenses for our already fledgling business with no regards to market factors, no help with financial institutions or any of the problems plaguing us. Please, before putting any more of these unnecessary burdensome regulations upon us, let's take a long, hard look at the market and the businesses in it. And let's create a path forward so we can all survive. I believe the department was required to provide an economic impact statement before the last rules proposal. Where is that? What's the average size of a business in the market? We should at least be able to see a slice of this, if not all. Everyone I know has a tax ID number. Where's the data? What will these additional rules and costs do to these small businesses involved? What size are most of the 4,000 businesses we're discussing here? How do we trust that OMP is truly considering what the effects of these rules they are putting on our industry will be? We've heard OMP testify in regards to methods like metric that there were no hidden costs and added labor would be insignificant. Then I just heard all the adult use registrants complaining about the burdensome time and added cost of the exact problems that were pointed out to the legislature and OMP in regards to metric in the past. At this point, I'd hope we will continue our moratorium on new rulemaking until some of these concerns can be properly addressed. I will submit a more detailed response to the new rules as I'm speaking more broadly here. Thank you for your time today. And I had a couple little notes. I know I'm over time.
Yeah, no, we'll look forward to the written testimony for substantive changes that we can make to help alleviate some of those general concerns that you do have. So thank you for being here. Vern, did you have any questions for Asher?
No, I'll look forward to his written testimony and the specific details there so we can maybe dig into that. Thank you.
Perfect. Thanks, Asher.
Thank you.
Okay, I think we're elevating Dave Vickers, and then the next three are Christopher Gudmundson. I'm sorry if I got that wrong. Amber Patterson and Matthew Bayless. So yeah, there he goes.
Well, hello, everybody. Hi, Vern.
Hey, good to see you again. How are you?
I like this better. I can see everybody as I'm talking. That's better. So listen, I guess I had like 3 or 4 things I wanted to just kind of hit some bullet points on. One of the first was, I think that it may be good policy to have, and we talked about this in the work group, that to have a continually, an ongoing conversation with stakeholders, right? And I was thinking it might be a really good idea now that the rules, the proposed rules are in the forefront of everybody, to potentially get a work group together, Eric, that is just medical. And, I felt that, and I said this when I, made application originally, that coming from the adult use side and the medical side, I thought would have a lot of validity, right? Because, I do know some of the challenges on the adult use side, right? I was pretty adamant about those at our work group, the challenges with metric and some of the other things. But now that the proposed rules are out, I do feel like, the stakeholders that don't have a lifeboat, and it was presented to me this way, so people, and I really try to be very open-minded when people chat with me, is that, you know, in fairness, if something did happen to the medical program or it got more challenging, I do have a lifeboat, right? I have the adult use side. And, you know, there's a lot of families and communities that are very, very dependent on the medical side, the patients. And I think it would be a really good faith move by the department, because you guys are doing awesome. You really are. I mean, you're engaging us, you know, today. Just anyone listening to this today would be proud to be in this program, right? And I think that might really show some good faith to, you know, I believe there's now 13 dispensaries, and I'm sure some of those now don't have ties to adult use. And we know there's thousands of caregivers. So that would be my first point. It's just, clearly we did not write the rules, right, from the work group. But at the same time, you know, get some industry folks that are just medical and involve them. And I think you can see that there's a lot of really thoughtful and caring people that will give good insight. The other thing I was going to say is just the tracking side of things. I'm at times, because I do so much with the metric side and I do it myself, I give pause to what am I truly doing? And I feel like at the end of the day, what you really want to know is what's the end product and how much of it is there and where is it going, right? So like when I do like weighing my, you know, when we defoliate a room, we weigh it and then we record it. When we move plants from one stage to another, we record it. I'm not sure what that's doing. I mean, I'm sure there's something on the metric side that's a lot of, you know, clearly above my head. But I would point out that at the end of the day, what you're really looking for is how much product was produced and where did it go? And let's be honest, were taxes paid on it, right? Because let's face it, that's part of all of this. And that it wasn't diverted, right? That it went to where, you know, you want it to go, those two things. So from that standpoint, I think it comes back to, in my mind, you know, a Maine revenue services spot. And I'm not sure it really falls back on OMP. Like, I mean, it's such an easy formula. Like when I sit there and I look at, you know, all the rules that are made up and constructed, I always look at things like, what is it? Who's writing those rules? Do they really understand the industry? Because at the end of the day, the value is in the bud, right? The finished product, and then what it turns into. And so from where I sit, you know, I look at this from the standpoint that it's a Maine revenue service issue. Plant count is, you know, it's about lights. How many flowering lights do you have? I mean, everybody in the industry knows there's a certain, you know, benchmark for, you know, how many pounds per light are produced. A simple formula could very quickly be, with an Excel spreadsheet, could have data entered, and people could, you know, on the MRS side, could literally look at that and be like, okay, does that fall in line? Does that match up to what's being reported in sales revenue? If it does, and it, you know, falls within an area, great. If it doesn't, ding, here comes an audit, right? So, I mean, I try to keep things simple. And you know, when I joined that work group, one of my biggest things was having clear and concise rules that lawyers weren't sneaky about and manipulating, right? That just the common folk could follow and handle. And I just think sometimes we make things over cumbersome to try to fix things that maybe the people who are trying to write the rules are either being somewhat cynical, or they just are uninformed. And then really the third thing I was going to say is just remember, when, you know, these rules and regulations are being written, you're creating a pay plan, right? You're first and foremost, we're thinking of our patients on the medical side, right? And their safety. And then let's be clear, we have thousands of families, the Maine economy, and you're really essentially creating pay plans for people. And one of the things in, you know, my previous life is, you know, I operated and helped run a large business here in Maine, was I was always mindful when I looked at my team members and I felt that things maybe weren't, let's just say they weren't necessarily moving in the direction that we had hoped they would move in. I always looked at the pay plan, because I said, am I creating a pay plan that puts people in a place that will lead them to success and the success of our company? And if you take that mindset here in Maine and say, okay, we're creating rules and regulations that will help write the pay plans of our caregivers, our dispensaries, the medical community, are they indicative of the direction that we want this to go? And I just think there's been a lot of really good input today. I won't mention names, but some folks who just came before me were wonderful. I mean, they really have good insight. And I just ask everyone to be open-minded about that and give pause as you're writing rules and regulations. Does this really help the industry, or does it push people away from it? Because the more people who are a part of this, the more tax revenue, the better our state continues to get. And that's where I would close, and I welcome any questions.
No, thank you. Thank you for that. I do have two questions. Obviously, at the end of the working group, and those that have seen us in front of the VLA committee this year, we do have extensive stakeholder engagement plans moving into 2022. It's
good.
It's certainly something that I wish we had done more of when OMP was first established. It just was one of those things that got kind of kicked down the rungs with higher priorities, like launching an industry and updating rules and this, that, and the other thing. My question for you is, this ongoing medical working group is something certainly we've talked internally about and considered. Would your vision be it more just in general, how are things going? What can we do better? Or would our time be better spent on like issue specific, like, all right, here's one big piece of the program that we think we could do better. Let's all get together, spend some time, however many meetings, weeks, hours, talk about that one thing, or a more universal ongoing working group. I don't know if you have any thoughts or have thought that much about it. But
I think it's a great question. I think it's both. I think it's like in a case like this, right? We now have proposed rules and regulations. So here's a time where I would, select, of course, and, people need to offer up their time and realize it is time consuming. I mean, all those of us in the work group, it was a lot of time, right? We put into that. But yeah, for sure. I think something like that. And then, if you just have a good line of communication, with that ongoing work group. And again, I think in this round, I would encourage it to be medical only. I really would, because I just think at the end of the day, that's probably the right direction to go. Or maybe you have one or two folks with adult use ties. Does that make sense? Like, say you had 20 people, and I know the more people you get, the harder it is to get things done. But, a very small fraction. Does that make sense? Because again, I do think having some adult use ties, especially for myself, hopefully that was useful. And I hope you appreciated it, and Vern and the crew. But yeah, no, I would have ongoing, but I would hit this right now. I mean, there's no rush, in life isn't about, unless it's life and death, take time. There's a lot of considerations that go on here. And this to me, it can be carefully thought out, and you can really win the public's opinion over and really make our state better, guys. You really can. I'm proud of what you guys have done. I really am. And I'm proud to have been a part of it.
And the other thing, thank you for answering the question. I love the creative thinking around MRS and being able to use them to track grow sizes and tax there. There's no excise tax, so there would be no play there for them to do that. But I think I understand what you're saying in general about just being creative and finding solutions that are less burdensome for sure. So I do appreciate that feedback and those comments. Fern, do you have any questions for David?
No questions. I just wanted to say thank you. I appreciate your input, and you've always got good thoughts, interesting things for us to contemplate. So thank you.
Thank you, guys.
Yes.
I appreciate your time.
Good to see you. Thank you. Take care.
Take care. Thank you.
All right. I believe we're elevating Christopher Gudmundson. Apologize if I get that wrong. Amber Patterson, Matt Bayless, Grant Hill. Christopher, welcome.
Hello, thank you. I hope I'm coming in clear.
Yeah, we see. Oh, we see you. We hear you. Perfect. Yeah.
You did very good with the name. Don't worry about that. Thank you very much today for allowing me to speak. Thank you, Mr. Malik, Mr. Gunderson. Once again, thank you for spending your time here with us, helping us get our word out there. As a medical patient and a registered caregiver here under Viking Gardens, I work at the Honeycomb Farm in Wilton, Maine, and going through a lot of the, paperwork and the rules and stuff that you guys are going over today. I'd like to just kind of hone in on one little subject that I thought would affect me personally too as well. A few years ago, I was hit by a semi truck here on Interstate 95, right on the exit of Sanford and Wells. I was rammed in the back of the car. The gentleman in the semi truck was reaching for his lunchbox at the time. I had a good lawyer with Joe Bornstein. He was able to come out of retirement and help me, get that process taken care of. And where I'm going with this will imply to where I'm trying to hone in on. So during that process, he told me at the end, you're at a young age, sir, but I do recommend that I apply you for disability. This is something I didn't want in my life. And I knew that I can continue to work and get taxes generated. And I knew there was opportunity out there. And because of the opportunity that you guys be able to provide it through, the OMP and, our state here with this wonderful cannabis program we have, I was able to get a job through the Honeycomb Farms, which is a really great place there. And they always have a designated area 25 feet away from the establishment, where I work. And I'm there a few days out of the week, and I'm not having to be disabled. And the reason being I can get through my days is I'm able to, indulge in cannabis while I'm there 25 feet away from the establishment in our designated area. And that's something of concern for that to be removed, because that's something that really helps me not be disabled. And that's something that, pushes me throughout the day, that helps me obtain that relief. I mean, when you have quality of life, when you're at work, you feel better. When you feel better, you work better. When you're working better, you're providing others better quality of life. So to have a bad attitude because I'm going through, my issues because of my back, my shoulder, and stuff that was injured that I had to go through surgeries for, that I obtained relief through, cannabis with, and not prescription medicines, which other people can be on and not have an issue of while they're bud tending and, helping, run the dispensary there. And it's a very tough issue to see that is something that is could be possibly going away. And I don't want that to go away, because people like me really have get relief through that, and we're able to go to our designated area. It's been very cold outside, so I don't really like to go to the car, but I've been fortunate to park over there and sit in the passenger seat and be warm. But I need that relief to be able to get through my day. It's something that doesn't affect me as far as performance wise. I think that having the knowledge overall and doing a good job of what you're doing is what you're going to be doing. Cannabis isn't going to affect that. And I don't want that to be taken away from the, from the rules that are already allowing us to do that, because this is something that's very important to me that helps me get through the day. It was a very tough injury that I had to go through. And I really choose cannabis to really help me get through that. It's something that I don't think is broken. I believe that there's a broad subjects today that are being spoken on that, that kind of seem like people want to fit, the laws want to fix things, but they're not broken, and these implemented strategies are going to take it away from so many opportunities for other people to become a diligent business in this. And it's going to be hard for them to conduct their business with all this extra stuff being added in. You guys are doing such a great job now. I don't see a big thing in changing some of these things. And that's, rather than to speak on everything abroad, I'd like to hone in on that subject there, really as a patient, as a worker. And, I'm also a registered caregiver too. And I don't own my own dispensary. I work at a dispensary, and that's something I want you guys to know, that I wish that to stay the same, because I don't think I could work without that. I don't want to be disabled. Like I was recommended that I should be on that, and I more than likely would receive it on my first try through a very respected lawyer that came out of retirement to do my case. And like I said, this is something I don't want to see happen to other people down the road, not just myself. It isn't a selfish feeling. I understand there's many other people out there that have other conditions rather than just physical pain. I'm a very big, tall gentleman. I'm a very large guy. It's hard for me to stand at a table constant without having the same. I was a former welder before this at the Kittery Naval Shipyard as an apprentice, and it took me away from that. And fortunate enough, cannabis saved me and put me into a new life. And that's where I've been delivered. So, thank the Lord, and thank you for the time that you've been able to allow me to speak on that. And I just don't want to see things that aren't broken and try to be fixed. And there's a lot of other subjects as well. So thank you for your time. If there's anything you would like to, speak on about that, but I really don't want to see that fact of indulging in that, allowing us to, be able to medicate properly with cannabis at the job. I hope that could stay. Thank you for your time.
Yeah,
Thank you.
no, yeah, thank you for coming and providing that testimony. Obviously, we certainly want to hear from you and others on that. And I think that's an important piece to bring up. Everything that we're doing here is to make sure that it, at the end of the day, benefits patients like yourself. So thank you so much for coming. Vern, do you have any questions for Christopher?
No question, just thanks very much for coming and providing your insight. It is helpful.
Thank you. I go by my middle name, Thor. A lot of people go by my middle name, Thor, but my first name is Christopher. Thank you guys so much. It was good to meet you for the first time. I look forward to seeing you guys as the future goes on.
For sure. Take care, Thor.
Thank you, guys.
Okay, so now we have, I believe we're elevating Amber Patterson, and then the next three are going to be Matthew Bayless, Grant Hill, and Douglas Gordon. And Vern, I'm going to step away just for a quick second. I will be back literally within 60 seconds.
Very good. Amber, are you there?
Yes, sir. How are you doing today?
I'm doing very well. Thanks for joining us, and thanks for your patience. You've probably been hanging around for a while. But the floor is yours, so go right ahead.
Thank you very much. My name's Amber Patterson. I'm a caregiver in Fayette, Maine. My husband is Brian Patterson. He owns the Honeycomb Farm out of Wilton, Maine. I just have a few things. I tend to sit and go through these papers over and over and over, and I have a million different things to say, so I'll probably just submit it in written. Quickly, I'd like to touch on our testing. Seeing as we still don't have proper standards for testing, extreme costs for testing, and the issue of bottlenecking that will occur if we end up being forcibly pushed to testing. We test anyways. I use Nova Analytical. They're a great company and they're usually pretty timely, but that doesn't change the fact that if we all are told, hey, you have to do this now, people aren't going to come to it in their own time manner, and we're going to get put to a point where it's inhibiting us instead of benefiting us. So I think as far as our standards go, we really need to get on a proper page, and that does come down to the state stepping in and utilizing their lab, and really coming down to something that everybody can agree on, whether it's chromatography testing or just terpene testing, whatever we actually decide to do, because there are several different methods for it. So that is hugely important. Tracking, I just kind of thought I would break down what I track. I track, of course, all of our sales. We're in a POS system, so all of that information is already tracked through it. We track our harvests, and I track our losses, which I think is pretty much what most people are going to be tracking in any business. In my harvest, I only track my flour, what I consider to be usable flour, and my biomass, which my biomass is what I'm turning into concentrates. So I'm not tracking every water leaf that I pull off, or stalk, or root ball. There's so many other parts of the plant that I don't want to be strapped with that level of burden. So the 3 things or 4 things that we actually track is our flour, our biomass, our sales, and our loss. And when I talk about loss, I'm not talking about, there were 3 grams off in my inventory due to water weight loss. I'm talking about, I had a crop maybe that was overrun by aphids, or I had seeds. I pop a lot of seeds, which when you're germinating seeds, you've got a lot of outside factors. You're talking about plants that possibly hermaphrodite. At about 21 days, they'll drop male pollen sacs, and they will cover your whole room. You'll think that you had all female plants, and then all of a sudden you get hit with a hermaphrodital female, and your whole room is ruined. And now that can be culled and sent to biomass, but it's something that I record as a loss as well, because I'm losing this huge amount of flour. Flour is where our primary income comes. Even though the biomass does alleviate some things, it definitely doesn't make up for the immense amount of loss that you have with flour. So as far as tracking goes, I would steer towards tracking what we do for our business anyways, not pulling in a bunch of randoms or even guesstimating. I know that I saw several times that 75%, wet weight to dry weight ratio. And although that is sometimes true, it's not always true. So you're talking about possibly saying, oh, well, they had 100 pounds of wet weight. They need 25 pounds of dry weight. Well, what happens when it's only 18 pounds of dry weight? And then I'm being told, well, where's your other 7 pounds? All of these things are very, they waver all across the board, whether you have a very dense nug compared to a very light nug. Those flours are going to be holding on. They're going to be retaining their water weight different. So I think that that's something we need to address, that you can't really go 75% is our magic number from wet weight to dry weight. Security. So at my primary, I'm at my home residence and I have a small garden. It's not something that I feel that I would need to burden myself with an ADT alarm, which is what we have at the shop, which costs thousands of dollars. They monitor it. We're a part of CCTV. Everything is already happening in the business sense. So for a business, I understand it. And I did hear you guys say, that it's not necessary for at home, but we're talking about outdoor cultivation areas. So my outdoor cultivation area at home could possibly fall under that. And every time that we make a change and we say, oh, well, that's just arbitrary, we're just saying that we're going to go back and change it. What happens is a few hands get changed down the line, and you and I may have had the conversation and you told me it was arbitrary, but at this point you're gone and I'm dealing with somebody else who's like, well, that's how it's written. And we have to be very black and white. There is no room for, oh, we'll just come back and fix it later. We really have to be 100% with what we're doing here, because my small business, if it does go under and Wellness and Curaleaf just come in and take over, all we're going to be doing is hurting Maine families. We're going to be forcing me to go work for them. We're going to be taking away their one person's salary by closing down my business. One person's salary. And they don't want us out here. And it's very evident that there's a lot of pushback from us cottage industry that built this place. But that doesn't change the fact that the big players, the wolves out there, see us and we're easy picking. I don't have the money to fight back, nor do I have the energy. I'm tired. Okay. I love seeing you guys. I do not like to come together like this. I would have rather sat in the work group and maybe tried to itemize our rules instead of possibilities and, thinking about what statistics were out there. I think that maybe in that rulemaking, there should have been rulemaking instead of just everybody talking about what they'd like to see. And I watched all of the hours of the rulemaking and I didn't see any rulemaking. So it was kind of like, what are we even doing here aside from, it was basically public testimony at a larger forum, So that's my security. The labeling, I could go on all day. I have one other thing that I really kind of wanted to touch about, it says pop-up in our prohibited conduct 11.1.2, section 3. You cannot have anything at a temporary location not under the control of either the registrant or the purchaser, including without limitation pop-up stores or meeting locations open to the public, or at any location under the control of the registrant, but not registered with the department. And I feel like that is, so for me, somebody who sells the majority of my flour in bulk to a store, I don't go and have to find additional patients, but to the regular caregivers starting out, they need patients, and you have to have safe medicating places. You have to have safe, accessible places available to them. So it's really kind of one of these things where it's like, oh, we want you guys to have a business, but we don't want you to be able to operate. And it's really scary when I look at all these small caregivers, and they do come to me a lot because we were such a small caregiver and we did transition over to a store. So they think that maybe I have the answer, which I don't. I'm lost just like everybody else is. And when I sit and try to navigate through the application process with them and give them good direction, it makes it really difficult because I go online, they change it. You look at something like this where everybody's been safe and you're allowed to go to a private area to work with patients. And now we're being told, no, you're not allowed to do that. We do not want you to have accessible medicine. We do not want you to have access to your patients. They should go to wellness. And that's all I'm hearing. So I'll go ahead and submit what I need to. The EIN, I think, is a huge issue. You know, I went through the process probably 8 times.
Hey,
over the
yeah, Amber, I'm probably a little bit more flexible than I should have, but yeah, the issues that aren't relevant to the rule is where I'll cut you off. But if you can get us that writing, it has been helpful though, because you gave that testimony like knowing exactly what questions we were going to ask and just took care of it all in one fell swoop. So
paying attention. I do love you. So
I do appreciate it. Vern, do you have any questions for Amber? And you are, I'm sorry, you do have written testimony?
I'm going to prepare more written testimony. I had some, but I feel like after sitting here, I've got more for you.
Perfect. Yes, there's no limit. Send what you got.
No limit.
Vern, do you have any questions for Amber?
I don't have any questions for Amber, but I think I might be able to answer some questions that she raised. I tried to take some notes. As far as the alarm system, so our intent, and we'll certainly look at the language because words matter, as you said, you know, our intent is not to require you to have security at your cultivation site just because you also happen to have a caregiver retail store. The intent is that the store is protected by the alarm system.
Yeah.
So we'll look at that, but I wanted to clarify for you what our expectation was when we were drafting that, what we were trying to say. The other thing is just in regards to tracking, there's no expectation in tracking we don't expect that in the tracking requirements that you'll be, you know, recording when you're pruning plants and, you know, fan waste and things like that, weigh in root balls or, you know, stalks or anything like that. We don't expect that.
A simplified bullet then, where you really are only asking for the 4 things because it seems overburdensome. It seems like you guys are you're fishing for data that's not even relevant. And it makes me feel a lack of trust, which I pretty much trust y'all with my entire business, all of my livelihood. If I didn't, I would be a black market or traditional market or a legacy market. You know what I'm saying? Like this is a choice on our part to come and sit in front of you. It's also a choice to give my local police station a knockbox. All of these things are choices that I've made because I don't want to be a black market worker. I would like to be able to sit down with you and have educated conversations where we actually come to a conclusion instead of leaving the battlefield feeling irritated at the last person. So that's really what it comes down to, Fern.
No, I appreciate that. And that's one of the benefits of having these public hearings is we get to hear from anybody that wants to take the time to commit to it. So we really do appreciate that part of it. My sense is from what you told us, I think you're already doing tracking and there might not be any kind of a significant change for you anyway, but it's helpful to know how you read those and how you interpreted them, because I'm sure you're not alone in that belief. So we need to try to clarify that, right, and work on that.
Simplifying it is the way, you know, I mean, 84 pages to maybe 20 pages. Let's simplify it.
I pride myself on being concise, but I don't think I can do that.
That would take some word magic and some editing and some for sure. Good to see you, Amber. Thank you for joining us.
Okay, hon.
Take care. All right. We are elevating Matthew Bayless, and then we're going to go to Grant Hill, Douglas Gordon, and Melissa Vayu.
Can you hear me? If for some reason my camera is not popping up.
Yeah, no, we can hear you. We can
Okay.
hear you.
I don't think you want to see me anyways. So.
See you plenty. No, yeah, feel free to fire away. I think we're all good.
Cool. Thank you. Good morning, Director Gunderson. Good morning, Deputy Director Malik. My name is Matt Bayless. I am a registered caregiver for the last 8 years. I'm also a adult use cultivator since day one, been about 1.5 years now. I'm here to testify in opposition to the proposed rules, not only for myself, but for the Maine Cannabis Industry Association. Myself and my group, we believe in regulation, oversight, and accountability in the cannabis industry. However, we find that these rules are ambiguous, vague, onerous, and overreaching in a lot of instances. I got some specifics here spelled out. 6.1.3D. When we get into cameras, I mean, we've talked about this one-on-one a bunch. I mean, you know, I was on the front lines of this as, you know, I transferred my 500 square foot grow from med into adult use and onboarded these camera regulations to the tune of $20,000. And, you know, there's a lot of ambiguous language in the med rules. Sufficient comes up a lot. I think that leaves a lot of room for your inspectors to kind of make up things on the fly. I think there should be a lot, if you're gonna implement cameras, there needs to be a lot more specific language to that. But overall, I think cameras don't prevent diversion. You know, I think cameras, unfortunately, are a costly penalty for those people that stay within the lines. And, you know, I think the 2A people make a good argument with gun laws where that, you know, it's only the people that follow the laws are going to follow the laws, and the people that don't follow the laws are going to do whatever the hell they want. And, you know, the cameras, again, are expensive. And they don't prevent diversion, unfortunately. So the next point I want to bring up is 5.8.1, 6.2.2 kind of overlap, where you know, where we got to organize as businesses, but then it gets into subsections B and E, 6.2.2 about what we do with our equity. I don't know if that's in statute anywhere. I think that's a gross overreach. You know, if you want people to come out of the cold and organize and be businesses, so be it. And especially, you know, make costly upgrades, then to come in with like a sweeping kick and be like, well, you can't sell any equity. I think that's unfair. And that starts to seed a lot of the mistrust and anger and frustration that you get a lot of the times with your feedback. As far as tracking goes, you know me and my love for metric. You know, I will agree with the caregivers that it's nice that you listen to the medical group on not implementing metric, but it does seem to be in your statute that in your rules here that, you know, you're just stripping away metric and putting in all the worst points. You know, planning all this tracking on a plant level is just molasses in the works for us. It really doesn't do anything to help with your oversight into the industry. You know, I think you know, there's been some good ideas today. The MOFCA example. You know, I have had members of the VLA committee in my grow over the fall and showing them metric, and they're frustrated with it. And, you know, they brought up the idea of creating a state portal as well. So, you know, it would be good. And, you know, if you did, like Mr. Vickers was saying, continuing good faith negotiations and kind of focusing in rather than having broad conversations, I think starting with a conversation about what a tracking portal could look like and things that we can all agree on. I mean, as business owners and as cultivators, of course, we want to track different strains and how they perform. And obviously we should be keeping inventories of plants and finished product and stuff like that. I think that's perfectly reasonable, but there is a lot of overreach here with getting down to the granularity level. It does create a lot more workload, and that creates expense for the business operator, and that trickles down to the end price for your patients. I think advertising is another overreach. I mean, I think the advertising should be in parity with the alcohol industry. There is some more vague language there, such as attractive to people under the age of 21. Who gets to define that? I mean, that's very, very vague and ambiguous. The concerns brought up about, your new licensing portal for med and how that dovetails into OMP requesting so much more information and data and processes. That rollout to the med portal is very cumbersome, and it doesn't really set up a good runway for more and more systems and processes for you guys to move through. And also on the adult use side, the IIC cards have really slowed down quite a bit and have become more cumbersome. Not an attack on anyone at the department itself. Again, everyone I've dealt with there has been more than gracious with their time. I think you guys are starting to have workload issues up there, and the med people are seeing it with their online portal, and the adult use operators are starting to see it with the IIC card turnaround. Lastly, I think there is a disconnect with outreach and what comes out in paper. You guys are in an unenviable position. I think, yourself and Ms. Pierce and Mr. Malik have been very generous with your time. But unfortunately, a lot of times we come away from conversations thinking that we've had some fruitful pass forward, just to see the language come up back out and just kind of slap us in the head again. And so I would like us to do some trust building and repair these roads that seem to be deteriorating. We're starting to hear that more and more, not just from med but from AU operators. The square peg through the round hole kind of analogy there. And let's not just talk about it, let's be about it as far as working as collaborators. I do have more detailed comments. I'm going to put those into writing and submit those as well. And I'm more than happy to answer any questions that you or Deputy Director Malik may have for me.
Yeah, no, thank you for being here. Thank you for providing that testimony. I'd say good to see you, but obviously, I think some of the most helpful feedback is, and I really take it to heart, is the terms like sufficient, where there's interpretation there. And I think Vern and others in the office would agree with you and me, saying what we're really trying to do here is have a shared understanding and as much clarity as possible with the rules. That's the whole purpose of having a rule. So that's certainly something that we can go back and look at. Vern, do you have any questions for Matthew?
No questions. I just wanted to say thank you, and we do appreciate the feedback.
Well, appreciate everything you guys do. And, one other thing I would bring up is another good conversation to have with stakeholders is we should really get into definitions, especially diversion. What does diversion really mean to OMP and to the state? And how does that directly trickle down into the rules? Is diversion an employee or a patient sneaking out with a gram or an eighth? Or is diversion, people that are exploiting the medical cultivation platform for black market gains? And I think that's where the clampdown needs to be. It doesn't need to be on people just simply trying to stay within the lines. So appreciate you all, and I hope you have a good day.
Thanks, Matt. All right, so I believe we're elevating Grant Hill, and then we have Douglas Gordon, Melissa Vayu, and Eric Sprague. Grant up.
Here I am. Sorry about that. I was outside listening to the trial or the testimony. Well,
certainly not a trial. No, welcome.
No. Thank you. Thank you, Director Gunderson, Mr. Malik, for your time. Thank you for the opportunity to speak to you and the department today about the proposed medical rules. My name is Grant Hill. I'm a resident of Portland, Maine. I participated in a lot of parts of the medical market. I was a caregiver at one point. I was a caregiver assistant. I'm a patient, but currently I work for MCR Labs, which is a testing facility in Gardner, Maine. The forthcoming testimony is of my own volition and my own opinion, and that which I say here doesn't represent the views of the company or its proprietors. So the proposed rules saw a number of improvements from the rules which we looked at last year. And this said, with these improvements, there are a lot of pieces within the updated rule set which still pose a lot of issues, as you're seeing today. So I'll jump into some of those quickly, trying to focus on specific sections. So first is those who spoke before me, the implementation and of a statement which places extra burden on regulators and stakeholders through a catch-all statement, such as any behavior not permitted by medical marijuana rule are herein prohibited. This seems to me like a great and reckless overreach, intentional or otherwise. Both Mr. Robinson, Mr. Subner, and many other stakeholders have spoken about this before me, and I agree with their stance to strike the line from the proposed rule in section 6.2.8. Second, attention to section 1.4.24, which delineates that cultivation, which is actually in the definition section. And I think that speaks to what Mr. Bayless was saying, is definitions, I think, need some more work. But which delineates the cultivation of medical marijuana must be cultivated in a single cultivation area. We've spoken a lot about this today, so I won't spend too much time on it. I wrote down a lot, but I'll keep it short. Just in my humble opinion, I believe that this specification should be struck, as it is a little bit out of touch with common cultivation practices. I think you, Director Gunderson and Mr. Malik, clarified this a little bit, but until this clarification is established with greater detail, I think this portion needs to be addressed. Third, bringing your attention to section 1.4.55. The rules should more clearly state that products purchased within a marijuana retail establishment for consumption of marijuana and marijuana products are not to be considered tobacco products. Let's see, sorry. And this is a common affront to the cannabis industry, which simply leads to a greater bias against our medical industry. Tobacco is obviously very harmful, which it doesn't have corollaries to marijuana. And while some marijuana consumers like to consume marijuana with tobacco, this is not inherent. We saw this confusion that this type of language created, especially in the VLA hearing on Monday, on the newer adult use rules. People like Scott Howard of Seaweed, Mr. Bayless, who spoke before me, were present at this trial, or the hearing, excuse me. And VLA chairperson and Senator Craig Fickman had spent almost 2 minutes clarifying an argument made by, I believe it was the municipalities, against the safety of marijuana use and treatment, when the evidence in the argument being made by the person arguing against was based largely on research for tobacco products. And I think I would encourage the department to look at this further and avoid any further confusion or bias by reworking this definition. Third on my list, and I know I've gone over my time, but I promise it won't go forever. Third, attention to section 7.3.2B2. I believe it must be brought to the department's attention that statute explicitly states records kept under this paragraph must avoid identifying qualifying patients. This said, I think that within this section, the address requirement should be struck. An individual's address, which is wholly and clearly identifying information. This is not just my opinion, or this is not just my opinion, but as an ethical standard, which I observed during my tenure in academic research for psychology, it simply would fall within those bounds of something that is identifying information. And I think just certification number should suffice. Fourth, attention to section 5.3.2a, as mentioned by many who spoke before me. The notion that medical cannabis businesses may be limited to operate as only a single entity without the same protections and complexities which regular businesses have is undue and contrary to statute. Fifth, and Michael Wilson spoke on this pretty clearly. Fifth, the fact that caregivers within the current proposed rule would be prohibited from meeting with patients. Also, can you see my camera? I can't see myself. No. Oh, well, so it goes. The idea that they'd be prohibited from meeting patients in a public location, I'd like to pair it what other speakers have said around safety of our caregiver providers and caregiver assistants / delivery drivers. And while dangerous activity towards caregiver assistants may occur in public, there are some de facto and protections that are in place inherent to a public meeting place, such as witnesses who may not be privy to the cannabis transaction, but who would clearly pick up on any attempts to either harm or rob anyone who is providing these services. These same de facto protections are not in place for someone meeting someone at a private residence. You're pretty much at the will of whoever you're meeting. And then pretty much that was the meat of my comments. And I will be submitting written comment with further detail on a lot more sections that I have interest in. All of this said, what I'd like to close with is just, as we talked about last year, support your neighbor, support the state, and please support the voices you've heard today from your fellow Mainers and overhaul these proposed rules. I second David Vickers' proposed idea of a new medical stakeholder group, something that perhaps could help you guys continue to refine these rules now that you've worked with the work group, but now solely with medical providers.
Great, thank you. The only thing I want to talk about, obviously, we heard the conversation around the tobacco products and the confusion there and the overlap between the definitions and different sections of law. Hopefully, the legislature will come to some clarity on that and what that impact will be, because we do hear about that quite a bit. But having said that, thank you for your testimony. And Vern, did you have any questions for Grant?
No, I don't think I did. Thank you.
Thank you for both your time.
Take care. Thank you. Right. I believe we are now elevating Douglas Gordon. Then it's Melissa Vayu, Eric Sprague, and Joanna Russell.
Hello.
Hey, how are you?
Good. How you doing?
Good, good.
All right. So thank you, Eric Gunderson, and distinguished chair members of the Office of Marijuana Policies for allowing us to comment on the proposed rules of Maine's medical marijuana program. My name is Douglas Gordon. I am a caregiver from Farmingdale, and my business is Ascension Farms. After reading the proposed rules, I am in opposition, being that they will hinder most caregivers from running a successful business. In section 2.2.2, it states, a registered caregiver shall be the sole equity owner of the business entity. As I understand this, it means that both my girlfriend and I will have to run our businesses separate from each other. This creates so many issues, not just for us, but for many caregivers throughout the program. Running one business is difficult enough, never mind two, especially with all the rules you have laid out in this proposal. Having to separate our businesses from each other means that we will not, having to separate our businesses from each other means that we will not only have to file separate taxes separately, that also means having two separate workman comp plans, two separate liability insurance policies, trying to figure out how to accurately split our utilities, and a plethora of other issues. All of the above amount to us having to pay double just to stay compliant. Some caregivers in the program are already struggling to keep their doors open, and these costs could be the difference between staying afloat and ending their business. I'm also aware you've opened up the ability for caregivers to go to the dispensary model, which I think is great, if you're able to do so. Farmingdale does not allow this, which makes this option unviable for us. Also, Maine Law Statute 22-2423-A 2-0 states caregivers are to be organized as any type of legal business entity recognized under the laws of the state. This includes several entities other than sole proprietorship. This rule conflicts with the statute. I also have an issue with the proposed rule in section 7.3.3-B. This would make delivery of product, especially in running a delivery service, almost impossible. Without the ability to make multiple stops, we would need to return to our facility after every delivery. This is not feasible for anyone. After harvesting, I meet with many caregivers to deliver product to their stores, and what would usually take a day to deliver all my product would now literally take days to do so. I, and most others, just do not have the time or money to pay someone to do so. This is in no way beneficial to caregivers or patients who rely on timely delivery of their medicine. There are also other issues I have with the proposed rules that I just could not fit in the time constraints we are given. One of those is section 7.2.2. This change will conflict with statute 2430-G. I will submit these issues along with what I covered today in my written testimony. Thank you again for allowing us to voice our opinion on the proposed rules.
Thank you, Douglas.
Thank you.
The only thing I want to mention, and I don't have the language up in front of me, I think this is the second time it's been brought up as far as the transfer of cannabis. I believe our intention is not only delivery of one order at a time. So you would have to go to your destination, go back, go to the next destination, go back, go to your next destination, go back. The intention is basically if you're transferring cannabis that it has an end destination. I think we will certainly bring clarity to that if that's been brought up by you and others. We can go back and do a better job of making sure that our intentions are clear with that, because we're certainly not trying to waste anybody's time or basically make distribution impossible.
Sure.
So thank you for being here and bringing that up.
Absolutely.
Vern, did you have any questions for Douglas?
No, I was going to mention the same thing that you mentioned about the delivery routes, and that's not our intention. So we'll have to take a look at that language and clarify.
Excellent. Thank you.
And just one last question for you. You had the 722 in the reference to statute. You have, I'm assuming you probably already said it, written testimony, so we can dig into that one. Okay, cool.
Correct.
Well, thank you so much for being here, Douglas.
Thank you. I appreciate it.
Yeah, take care.
You as well.
Okay. I believe we're going to elevate Melissa Vayu, and then it's Eric Sprague, Joanne Russell, and Brian Patterson. Melissa, you should be here as a panelist if you want to unmute yourself and turn your.
All right.
There we go.
All right. Thank you so much. Hi, I'm Melissa Vayu. I live out in Windsor, Maine. I don't even know what I am anymore. I'm a patient foremost, helping friends build out, consulting, growing, what have you. I really want a future in the medical cannabis industry, but it's kind of making me nervous. So I'm just going to read my statement. I appreciate the opportunity to speak on just a few of the excessive amount of rules OMP is proposing. With these, I can assume that OMP, you do not know personally what it takes to grow medical cannabis to the quality standards that a lot of us already have, because it is our medication too. Your proposed rules are showing that you're not understanding that this process takes time, even before one plant is potted. The money, the anxiety, blood, sweat, tears, life savings that goes into this. And then when we're granted permission with OMP as a caregiver, it feels that we are still being treated with a criminal mindset. The rules you propose to us are a blatant slap in the face for trying to do it right, do it the right way. It is an abuse of overreaching power all through it. A few examples are the security. I mean, I hope to open a store one day, but my understanding is that as an American citizen and a private business owner, we can choose to have a third-party surveillance if we want, whether it's for insurance reasons, whatever. Otherwise, a motion camera over the building's exits of the business, cultivation facility, lab, et cetera, is all that is needed. I'm going to assume that theft is OMP's first worry. I am too. No grower storefront wants their hard work stolen. And trust me when I say, in this industry, people know when something is missing. As far as the record keeping goes, you could have just said metric instead of wasting all that ink. Couple examples, the records OMP wants us to keep, which plant a room is in. Do you want me to log all the floor weed that I swept up from trimming and the what have you that just gets tossed aside into the trash? It just looks like another overreach in section 7.2. Also in section 6 is riddled with treating us and whom we choose to associate with that criminal mindset too. It's my home, my place of business. So it seems like if you're telling me my 87-year-old grandfather can't swing by and say hi, and I can't show him, look, Grampy, I'm really proud of all of our accomplishments. We have the right to deny or allow anyone on our property, a plumber, another caregiver. Some, in my opinion, always need permission, and that is with OMP inspectors. A request to schedule an entrance would be so that OMP isn't interrupting, a normal business day, getting all what OMP would want. Also, what if I'm medicating? That's a good intro into another overreaching point. It is no one's business to tell someone they can't take insulin in front of anyone or a child seizure medication. So why would anyone be refused to medicate with cannabis when they so see fit? They could have a seizure disorder. They could have it, whatever. It doesn't even matter. You have no right to tell someone they can't medicate with medical cannabis unless all of the OMP guideline parameters are met. That just seems ridiculous. OMP is not my doctor. OMP is not my body or brain. OMP is not God. These time statements are never enough, but what could have been more productive is an actual work group with OMP that had only medical caregivers, patients, or storefronts. There is absolutely no need for a majority of the panel to have adult use ties. None. There is no reason, excuse, explanation why the last work group wasn't only medical. These rules, again, need to be shredded, deleted from hard drives, need to not exist so that OMP actually listens and writes in layman terms what they want. We are all speaking today because OMP is not listening again. A lot of us are getting really tired being treated like we don't matter and are just criminals trying to come into the legal market. A lot of caregivers have also told me they only went into the adult use market because they're banking on medical failing. Well, I'm banking on medical succeeding because all the eggs are in this basket and we're Mainers. So the bottom line is we hope that you listen and that the legislation really hears the people. So I appreciate your time and thank you.
Thank you for the testimony. Vern, did you have any question? Where'd she go? Oh, there, she's still there. Do you have any questions for Melissa?
No, I would just say thank you very much for your testimony. We appreciate it.
Thank you. I was a little less anxious this time.
Yeah, it was great.
Thank you. Have a good day.
Take care. All right, I believe we are elevating Eric Sprague, and then the next three are Joanne Russell, Brian Patterson, and CJ Hagan. Nope. Looks like we have Eric Sprague, and then the next two are Joanne Russell and Brian Patterson. If anybody else wants to provide testimony, I would ask that you raise your hand because we are coming to the end, and I would certainly not want to close the public hearing if you do have testimony that you want to give verbally. So there we go. Okay. Sorry about that, Eric. How are you?
I'm good. How are you?
Good. The floor is yours.
So I'm a home caregiver out of Wells. I've been doing it for about 2 years now. I am in opposition of the rules. I think it's a broad overstep of, your guys' ability to make the rules. I think there's a lot of parts of it that really just attack us small guys. And I think that when it came to the work group and it came to, us small guys to say, we didn't really have much. And I think, as Dave Vickers and other people said, I think that we need to have that. I think, and not just in Southern Maine, I think in every county, because Maine is a big state and you have people in Northern Maine that are dealing with totally different business than someone like me in Southern Maine deals with. And having everyone on the same thing and expected to have everything the same way, I think is just, it doesn't quite work. a guy someone like me who's 250 square feet in my basement versus someone who's got, 1,000 square foot, room, we're on two totally different levels here. We're doing two totally different things. To acquire someone, making us have to essentially have a trip ticket, and have to go back and forth between everywhere I go. If I'm going to do deliveries to storefronts, that could make it a week-long process. And for someone like me, where I do everything, it's just me. There is no one else involved. There's no one else that really helps. So to have to, try to balance something like that, it's impossible. It's impossible to, require some, certain things like that, and require some of the record keeping that, you guys have put on there in 7.2. For someone like me, I keep track of when we harvest, we keep track of wet weight. I keep track usually, end product dry weight before it goes out. And usually there's a certain percentage where it goes in the trash. To me, I don't want to put it out there. So it gets, put in the trash. But if I'm in my room and I'm clipping leaves off, I'm not thinking about putting them on a scale or, because it's not usable. It goes in the trash at the end of the day, and that's that. And I think that's just, having a better voice for everyone in this industry, I think, is where we kind of just need to go on everything.
Thank you, Eric. Vern, do you have any questions for Eric?
No questions. I just wanted to say thank you. I appreciate your feedback on these things. And just to throw out there, the trip ticket language is not new. That's a requirement that's been in existence for years. But just wanted to throw that out there. That's not an expansion of anything else. It's just it's already in rule.
Okay.
Eric, you said it was just you, so no other employees. You're cultivating, distributing, one-man show. Okay.
One-man show, everything. I'm looking. My fiance is looking at getting her caregiver's card to do some outdoor growing this year, but we're kind of on the edge about it because if certain rules change and stuff, and it makes it impossible for us to do, there's no point in spending the money and doing it. And because it's an expense, it is a huge expense to take on. Being a small business, I provide for my family doing it. And if, if rules pass and the medical market shrinks or disappears, that puts someone like me out of business, and I'm able to provide for my family and, be able to do that comfortably and not have to worry about living paycheck to paycheck and worry about, where's my next bit of money going to come from. And I think that's what's important, is protecting small Maine. Maine was built on small business, and that's what's always been important for Maine. So I think that's what you guys, should just take into consideration on it.
Absolutely. Well, thank you for being here, and thank you for providing the testimony, Eric. We do appreciate it. Looks like we're elevating Joanne Russell. And then the next three are Brian Patterson, Ben Shaw, and Susan Meehan. Hello.
Hi, thanks for having me.
Thanks for joining us.
Thank you. My name is Joanna Russell. I am a small, non-cultivating, non-storefront food producer out of South Portland, Maine. And I actually have some questions before my testimony because the answers will actually impact my testimony. I've heard and read very different pieces of the rules, and I'm really struggling to understand whether a food producer alone, licensed under the Department of Agriculture, who's not extracting, qualifies as a Tier 1 manufacturer.
Are you currently registered with our department?
I am.
Okay, so you would be able to conduct that authorized activity without being a standalone manufacturing facility.
Okay.
Believe me, it's not lost on us. when that went language specific to manufacturing facilities went into statute, it was confusing to us when we first inherited it. And since there's been even more changes, it's really up to interpretation if it's even needed. But if you are a registered caregiver and you're operating a kitchen, that authorized activity is inherent in your current registration.
Okay, so I wouldn't have to register as a tier 1 manufacturer in that case.
That's
Okay.
correct. And I'm
No-
sure my explanation was rambly, but yes.
No, well, that's the way I've interpreted it this whole time. But when I went through this rule book, the tier 1 and tier 2 manufacturing guidelines were kind of included in this rule where they've typically stood separated. So it just caused some confusion for me as to whether or not that was going to be a change. So you've significantly decreased my testimony time. Thank you. I do want to touch on 6.2.2 and just reiterate what others have said about sole equity ownership, as it is kind of a catch-22 if we did have regulations imposed on us that require an influx of cash. It limits our ability to do that. I also want to talk about 6.2.8F, where it seems to contradict the possibility of expanding into adult use and co-manufacturing at some point in the future if I choose to do that. It reads to me as if it's saying that should I co-locate, I could no longer sell direct to my own patients as a caregiver. So I would love to have that looked at, and I'll include that in my written testimony as well. As far as inventory and tracking, I can tell you that as a food manufacturer, I do that anyway, but I think that my particular needs will look very different from other parts of the community. So I think that does warrant maybe a different set of considerations. I can tell you that I track my inventory daily, and I do that to compare it to the previous day to make sure that things that have been left out to cure overnight or for 2 or 3 days are all accounted for before they end up in packaging. I do it also to compare the number I was expecting into the bags that I yield, and it has caught us from making mistakes. So it's a safety issue in my business. And so I do it voluntarily, but I don't keep those records over time, and I don't compare them to sales records. I do it for the sake of safety. In terms of food packaging, I would also like to just bring up 8.2.2 B6, it looks like. And it does say something to the effect of labeling an edible product with the total net weight of edible harvested marijuana separate from package and label. This makes no sense to me. If I'm labeling a food product and I've described it as 10 milligrams, it's not really relevant if the original concentrate that I used equates 10 milligrams to 0.00 grams of concentrate in the edible. It's irrelevant. I've marked it as 10 milligrams. I have a test to back that up, and why that exists, I just don't find the purpose in that. 8.2.2 B7 includes an additional warning label, and I can promise you our packaging is fully compliant. We've got every warning listed on there. We've gone above and beyond and included even some adult use warnings. Just for the sake of it, we are out of space. We can't fit anymore, and we're just out of space. And we're really, really trying to do a good job with our labeling, but the amount of warnings is getting a little bit difficult to manage in terms of packaging. And to add on to that, if packaging changes are going to be made in general, I'd really like to recommend that they be phased in over time, as manufacturers have to purchase large amounts of packaging ahead of time in bulk in order to get our prices where they need to be. And we could be really sitting on a lot of inventory that we have to move. So I'd like to recommend that. And the rest has been reiterated in other parts of today's meeting.
No, and thank you for making that last point. We certainly made it last year when we were going through this rulemaking process. It's not lost on us that there have been significant changes to the program over the last 4 years, and there will be some, I mean, even if we were just to copy paste the statute into the rule, there would be significant changes to the way individuals operate. And we understand that if that went into place, people such as yourself running a business wouldn't be able to be in compliance in day one. We understand the business and human aspect of it. So certainly willing to work with industry on those front. Well, I guess the question I have, you have a bunch of warnings on your products, on your current labeling, and we appreciate you going above and beyond for the purposes they had served. Where are you getting those? What warnings do you currently put on there?
I have the one about pregnancy, breastfeeding, driving a motor vehicle. I have the one that it may not take effect for up to 4 hours. I do put a nutrition label on mine, which takes up a lot of real estate on my package. We have the ability to do it, so we do it, even though technically we don't meet the requirement for that yet because of our business size. But we do put it on. We're required to put address information on our labels by the Department of Agriculture. But those are the two major warnings, and they take up a significant amount of space. And then there's, batch to batch differences that we have to allow room to put on a sticker that we print for each batch that goes out that we're putting on in addition that needs to be, that we need to have room left for on our packaging.
Great, thank you. Vern, do you have any questions for Joanna?
I do not. Thank you very much for your time and your patience in hanging in there with us through this hearing. It stinks to be one of the last ones.
Actually, I really want to say I appreciate it because, listening to the other caregivers and all of you and the interactions has actually given me quite a bit of confidence to do it, where I feel like a fairly new caregiver, and it's hard to speak up about within an industry that's really large and kind of feels a little over my head. And when we have to sometimes talk about the fact that we might not feel compliant and talk about it. So thank you to everybody who's gone before me and given me some nerve.
No, thank you for joining us. We do appreciate it. Take care.
Thank you.
All right. So we are elevating Brian Patterson, and then we have Ben Shaw, Susan Meehan, and CJ Hagan. We seem to be juggling the last few at the end, but I think those are the same names. Brian, floor is yours.
Sweet. Can you hear me?
Yep. See you.
How you doing? So my name is Brian Patterson. I'm the owner of the Honeycomb Farm. I'm going to make this quick and easy. Few of the subjects I'd like to talk on, the patient's access. So I allow my patients, I allow my employees to access their medicine while at work. In there, you guys state that they are not allowed to utilize cannabis, alcohol, or anything at work, which I understand alcohol, but nobody says that you can't take your blood pressure medicine at work. So why can't we allow our patients or our employees to utilize cannabis at work as well? Another thing that I'd like to throw a quick hit at is the tier 1, tier 2 manufacturing. You're only allowing the people to manufacture 40 pounds of harvested material. Well, is that dry weight? Is that wet weight? How can me as a manufacturer, which I do have a class 1 division 1 lab, how can you determine how much weight that, so you're saying that, 40 pounds of wet weight is only the equivalency of maybe 10 pounds of dry weight. So that doesn't make sense for a tier 1 manufacturer to only be allowed to have 40 pounds of harvested material, because that's their harvested wet weight. As a caregiver, I'm allowed to have whatever I had harvested. So are you giving me limitations as a caregiver of how much I can harvest? What's going on there? There shouldn't be any kind of limit and as a storefront, I can have easily 40 pounds at my storefront at any given moment. 200 pounds of harvested as a tier 1, but like I said before, you can possess all of the harvested cannabis as a caregiver. So why are we even lumping an amount into the manufacturing facilities for the tier 1 or tier 2 for that? Also, can we get an impact statement for people that have to move like their facilities? So you guys are, my lab is in a non-opt-in place. So now you're just in a non-opt-in town. So what if my town doesn't does my town have to opt in? They only opt in for anything medicinal. So now do they have to opt in for a lab now, or what's going on there? Sorry, I'm kind of winging it. So anything else? That's about really what I got for you.
I think at this point, the manufacturing statute has become so confusing, not only to industry, but also to us. So if you're a registered caregiver, the tier 1, tier 2 would not apply to you. I think it's for standalone only. It's just statutory language we used. So I don't know your exact business situation and model, but I'm guessing that those cannabis limits wouldn't apply to you. Certainly there's value in some of the statutory language around the IHS stuff. But thank you for pointing that out. I think we can do a better job of getting clarity around that and potentially asking the legislature to either remove or clarify. But certainly there needs to be something done there.
All right. Now, what about the work group? Why wasn't there any kind of manufacturers that are using inherently hazardous gas in there to represent us? Why weren't we? Because I am using inherently hazardous gas, so substance or IHS, whatever you want to call it. Why wasn't there anybody else that represented any kind of C1D1, groups of anybody in the rulemaking? And now we have this, rulemaking thing. It just seems like you guys only wanted to focus on other stuff, and we need to get more involved, more community involvement. I mean, like some people say, you need more patients in there, you need more caregivers. It seems like you guys had thrown a bunch of shit at thrown a bunch of stuff all at once and only took what you wanted out of it and didn't really take what we wanted out of it. So,
well, certainly that's not how I would categorize or describe the process we used. First and foremost, there was a seat for a medical manufacturer, and they did serve on the working group, and we did have conversations around that. So, just a little clarity there. Vern, do you have any questions for Brian?
Just wanted to clarify one point for Brian, and really for his employee, I think, has also raised this issue around consumption while working. If you look in the rule under the proposed rule under section 6.1.2D, it does allow for you to continue to do that. It says, except a registrant may allow an assistant who is a qualifying patient to consume legally obtained medical marijuana or marijuana products, so long as no qualifying patient or visitor sees, smells, hears, or otherwise observes the consumption. So I only point that out just to try to maybe alleviate some of your concerns around that. I understand it's an ongoing thing that that some folks are relying on, and it's important to folks. So just want to kind of clarify that a little bit. Our proposal doesn't intend to prohibit that. Just want to put some parameters around it, not exposing others to it. That's all.
And thank you for pointing that out, Vern, because earlier I think Chris also brought that up. So, well, thank you for joining us today, Brian.
Thank you. Have a good day.
Take care. All right. Looks like we're going to elevate Brian Shaw and then go to Susan Meehan and CJ Hagan.
I think it's Ben Shaw.
Oh, sorry. Yeah, sorry. Ben, it looks like you've been elevated to a panelist. You should be, there we go, unmute, yep.
Can you hear me?
Yep, welcome, the floor is yours.
Hey guys, how's it going? I wrote a big long thing today, just listening, but I'm not gonna make you go through all that. I'm gonna hit a couple points real quick. First one I got a question on was manufacturing. Just with the concerning my concern being pre-rolls and like rosin, which is, you know what I mean, nothing's being used there that's anything crazy. It's kind of just, you know, like things everyone does, and it's not like, it's not hazardous, not anything really added, you know, it's not much different than trimming or doing any other typical activity. So yeah, just my that transfer of clones. I don't have a number written down here, but I believe I saw something limiting transfer of clones. I will try to look that up and send in written testimony as well. But I mean, that's important to patients and small growers alike. You know what I mean? There's people that don't have the space for such things, and for patients wise, it's always helpful. And then other issue was with the like more specific tracking of batches and whatnot in cultivation. You know what I mean? Like we're a small company. We have like, you know what I mean? It's mostly me and my girlfriend doing a lot of stuff. You know, we work 84 hours a week, typically 100 hours on harvest for about a month straight. You know what I mean? So like adding more paperwork into there is pretty hard. You know what I mean? Like we could, you know, I mean, we could hire someone to do that, and obviously there's systems, but it all just costs money. So, you know what I mean? It's kind of down to that, and just I feel like it's kind of it's pushing smaller people out, which isn't I don't know, that's not, you know, that's not what Maine's about. I don't know, I mean, if any like rule makers want to come work with us for a day or whatever and see what it's like in the life, you know what I mean, of pretty much working when you wake up to when you go to bed, which, you know what I mean, we all love doing, and it's not like you know, we're not complaining about that whatsoever, but it's like you can't add more hours into a day is what I'm trying to get at on that one. You know, if we could add more, we would for sure. Packaging for older people, like exit bags are pretty hard to get into. When we had our inspection, they seemed on the fence on like if paper bags were okay or not. But you know what I mean, for the older people, with everything else being child resistant inside, I feel like we should kind of keep that in mind, where we are medical, so it's older people. And I don't know, the exit bags are tricky to get into sometimes. And for, you know, cost wise too, they do get pricey, and if you have to cut them open, can't reuse them, whatever, it's just a lot of waste. So if we can keep that in mind. We do delivery. So another thing I wanted to hit on was the safety of the public meets. So ruling out public meets for delivery is kind of silly. I mean, there's much higher risk at a home address, because I mean, you're not necessarily going to be at the place of your ID always, or so on and so forth. You know what I mean? So if you don't have the right address, then that leads to problems in the past. And you know what I mean? I'll submit some more, and I'm willing to sit down and talk about those risks that are there and potential. But like public meets, you know what I mean? We in Portland area, when we started delivering out there 4 years ago, we did talk to a lot of like local police and stuff, and just kind of touch base, and we're like, hey, you know what I mean, we just see them around town, just like whatever, and just stop and talk to them. And we would just be like, hey, you know what I mean? This is what we're doing. Like, let us know if there's any issues or whatever. We're going to be in the area. You're going to see us around probably quite a bit, you know, driving around. So like we have had like even on, so like on a public meet, we've had Portland PD pull up to like a delivery driver and just be like, and for like a actual story of scenario of what a public meet could be like, you know, public meet like this was at Hannaford's in Portland, and you know, so probably our busiest, most populated, you know, city of Maine. I think that's general statistic probably, but the driver, the cop pulled up to the driver in the Hannaford parking lot, and then he rolls down his window and he's like, hey, he's like, you from Peak, and then he thanked us because we were helping his older dad who wasn't able to leave the house, and like he was like super appreciative, super nice, like great experience, and like, you know, what it's all about in all reality. And we, you know, and then he laughs and says, I don't want to spook your patients or whatever. So he laughed and said and went on his way. But you know what I mean? Like that's they know we're out there. They, you know what I mean? It's the same first. It's the same people. You know, we're in Maine. It's like as long as, and we have worked with like Portland PD has called us in the past when they had issues with people, and just like for instance, they called us and just asked it was a little tricky because I didn't know how much. I didn't want to release any patient information, but it led down to, we had I don't know, there were some kids or something in Portland that robbed a handful of places in one day, and they had order from us, and we did have record of that, and we worked with them, and you know what I mean, we're like, oh yeah, like this is what we have for contact info, and they just really confirmed where it was going and this and that. But like we do all that on our own really. So it's I don't know, people everyone wants to be in compliance and does our best, but at the end of the day, a lot of these rules is just really like, it's just money, and that money is going to get passed down to the patients. And what I was thinking recently as well was and started to look into, but I think everyone's on the same page at this point that it's a medicine, like even not just here, all over the US, but medicines typically, other than 2 states, medicines have a sales tax, and maybe we should look into or watch what Oklahoma's doing and maybe put some medical sales tax over onto the bigger 20,000 square foot canopy. That's 40 times what a small guy can grow. Like let the locals who put the work in and we're, you know, I mean,
Ben, I've been really lenient with your time, and now we have kind of drifted off into tax policy, which is way outside of what we're talking about.
Yeah, but I'm just saying. I just want to say, like, if you want us to do more things, like a little give and take, just you know, we need money to make it work, or to make current rules work is my thought process there. So
absolutely,
just trying to help find a end game that makes everyone happy. You know what I mean?
Yeah, if you could send along that written testimony just to give us a little more clarity around your concerns with the transfer of clones. We certainly got your feedback around the public meetings. But Vern, do you have any questions for Ben?
I just had one real quick, Ben, because it is getting late in the process here. But so you do deliveries. Do I understand that you don't do any deliveries to a residence? You only meet in public places?
No, not at all. We do deliver to plenty of people's homes. Like, you know, we help a lot of older folks that can't leave their homes and this and that. But ruling out the public meets, which is like, you know, like if they can't quite, or if they're in the area or something, you know, like, there's no problem with it is what I'm trying to get at. So I don't like understand how to why to rule it out. You know, don't fix something that's not broken is my thought.
Yeah, I guess the only reason I was asking the question is I've heard the concern from others about the security of not wanting to go to a patient's home, so you meet in a public place, but it doesn't sound like everybody's doing that. So I appreciate you taking the time, and we do look forward to the written testimony so we can get maybe a little bit more detail on some of those other points. But I think we're getting ready to move on to Susan Meehan, who's up next.
All right, thanks, guys.
I'm still on mute. Yes, thank you, Ben. Looks like we have there's Susan, and then we have a new hand. We have John Roy and then CJ Hagan. Welcome, Susan. Good to see you.
Thank you. Good to see you too. Thank you, Director Gunderson, Mr. Malik, and our technology experts. My name is Susan Meehan. I am a caregiver and a patient. I serve as the chairperson of the Maine Cannabis Coalition, a nonprofit where I represent an audience of over 5,000 across multiple social media outlets. And I also serve on the Maine Cannabis Council. I came to Maine in 2013 to utilize the medical program to treat my daughter Cindy May's devastating seizure disorder. Off the prescribed drugs that had kept her seizing and bound to a wheelchair. In her last 3 years, Cindy May enjoyed playing like a normal child in the streams and snows of Maine while fighting for better access in several states. As a member who served on the OMP work group, I also want to state that the work group did not write nor review these rules ahead of time. We got the first glimpse at these rules when the public did. And the work group did vote down track and trace and mandatory testing, as Director Gunderson had talked about. While there are improvements upon the 2021 draft, there are still some serious issues with this 2022 proposed rules that demonize the plant. Cannabis is medicine and does appear to alleviate some symptoms of some serious illnesses. See US Patent 6630507. Section 6, 7, and 11.1.2a of these proposed rules color a problematic situation of bad smells and dangerous plants, pushing it back to alleys and secret deals. Eliminate 6.1.2 G2, 6.12 D1 through 4, 6.13 C2, 11.1.2a, and 6.22. Carve out section 9 to reflect statute. These are cannabis businesses. When one goes to a pig farm, does one see, smell, hear, and witness pigs? The proposed rules around advertising would make one think that cannabis is more dangerous than the openly advertised and consumed alcohol and prescribed narcotics and opiates that are killing our people. Vehicle wraps and clothing apparel are not OMP's mission. The world is drowning in alcohol advertisement. Please eliminate most of section 9. Section 7 of OMP proposed rules take this from transfer tracking to daily inventory tracking, basically recreating metric on paper. Section 7, letter O, describes a currently optional form used by some caregivers to track transfers. Basically answers, what do you have? How did you get it? Where did you get it? And did you pay your taxes? Which are the things that I think OMP really needs to know. As businesses grow, a simple bookkeeping program will likely be enlisted, and the banking industry is in the process of helping out with transfer tracking. It is unnecessary for OMP to mandate these things, including monitored security systems and cameras. Other services industries, such as the insurance industry, are managing this as small business grow beyond the walls of the family home to a more commercial platform. Section 6, especially 6.2.2, hampers the growth process of a small business into a middle-sized business. Not everyone wants to be a dispensary. Illegal distribution and sales hurt caregiver businesses that are properly reporting sales and paying sales taxes. But I don't think anything in this proposed rule will stop the law enforcement issue of black market. Maine medical cannabis businesses must be wholly owned and operated by Maine citizens per Title 22, Chapter 558C. Further, subsection 2423 states that a caregiver may be organized as any type of legal business entity recognized by the state laws of the state. Eliminate 6.22, it attempts to restrict caregivers far beyond the residency requirements. It is a disaster. In the vote to pass LD 1242 into law, our legislators sent a loud message to OMP to engage the stakeholders in the rulemaking process, among other things. This industry paid millions in taxes in 2020 to the state of Maine and over $250 million in sales, driven by approximately 3,000 small businesses owned and operated by Maine residents. Sales tax, employment taxes, income tax, money spent in ancillary businesses such as insurance, HVAC, electricians, contractors, carpenters, dirt, security systems, graphic design artists, performing artists at local festivals, etc. Locally owned small businesses in Maine spend money in Maine communities. Is there a fiscal analysis for the proposed rules? The real stakeholders in this industry are the Cindy Mays, the patients whose lives have been improved by Maine's medical marijuana program. Please further engage industry stakeholders, including more patients in this process. The work group and the 5 meetings were a great start, and the work group could have provided an analysis and test run of these proposed rules. Many of us, including the author of LD 1242, believe this was the purpose of the work group. On written testimony, I will provide spreadsheets and details, and I thank you very much for hosting this meeting and managing this long day.
No, thank you for that. The closing statement, you were rattling off section numbers and I was just stopped writing them down. So that would be really helpful. So thank you. Vern, do you have any questions for Susan?
No questions at all. Thanks for hanging in there with us.
Yes, thank you and good seeing you. All right, we're going to elevate John Roy and then it's just CJ Hagan. So if you want to provide testimony and you haven't yet, I would suggest that you raise your hand. So elevating John and then CJ. John, looks like you're in the room with us and there you are.
Hi. Hi, my name's John Roy. I'm a Maine cannabis patient, and I got to say that I'm blown away with our cannabis program. It's awesome to be part of the craft cannabis situation happening in Maine, and I'm really, really happy to be here in it. When I saw 1242 go into effect, I thought that the patients in the medical cannabis community were going to have a say, and I really feel like there should be no adult use ties whatsoever. And, you know, when I see who's representing me, I don't feel quite right about that. It is what it is at this point, but that's my opinion on it. Also, the metric system, it's failed in so many other states. It's the last thing I want is to implement more rules, regulations. To me, I don't care how much THC percentage. I want to know who grew it. Their reputation is more to me than a test that could have been botched, failed, what have you. You know, other than that, I thank you very much for giving everyone plenty of time to say what they want. And you're doing a great job.
Thank you for the kind words. We do appreciate it.
Thank you.
Vern, do you have any? Oh, hold on. We might have questions for you, John. Vern, do you have any questions for John?
Good. Thank you very much.
Perfect. Well, thank you, John, for being here and
thank you
and waiting. Thank you. All right. The last individual that has their hand risen to provide testimony is CJ. And then if nobody else has their hands risen after, well, I'll do a call right after CJ is finished to make sure that we've captured everybody. All right. Hello.
Hey, I'm CJ. I'm from Green Extracts. Me and my wife own the business. We have we're totally vertically integrated. And we have a production place in Parsonsfield. We have a storefront in Limerick. And just a little background for you guys. I got into this industry because I had cancer many years ago. Went the traditional route, did everything doctor said. Cancer came back a year later, even though they told me it wasn't going to. So the second time I told them I was going to go my own route. I chose cannabis and have since been cancer-free for 12 years. So I'm telling you this because as a caregiver, the medical program is near and dear to me. And I don't really have intentions of going the adult use route, but I will say I've had second thoughts about going the adult use route at this point based on some of the things that have been proposed. And while I got you here, I mean, I have a huge list of things that I would love to address with you guys. I'm just going to send in written testimony at this point. So I'm just going to bring up a couple of the main points that I want to make with you while I have your attention. One of my biggest qualms with the medical program is now that there is an adult use program, a recreational program on the med side, there is not rigorous testing going on. And based on my experience of what I've seen as a shop owner, as a caregiver for years, there's a lot of products out there that aren't going to pass testing that caregivers are passing off as medicine right now. And I mean, it's kind of appalling seeing these people who say they're medical providers providing medicine, providing us with oil that is loaded with pesticides, or it won't have the product that you want. You know, they'll tell you it's THC oil and you find out half of it is CBD, or now they're making Delta 8s and different adulterants and whatever. And I would love to see a little bit more robust testing. Now, I've heard the arguments from all sides of it because, you know, we produce, manufacture, and sell. We're kind of known for being very, very in touch with our patients and being very knowledgeable, and we love interacting with them. And I feel like I'm speaking for them when I say this, that, you know, as much as I want testing, I understand some of these qualms that they're having, and, you know, people don't want to be spending the money to do it, or it's too rigorous, or maybe the testing places don't have strict standard operating procedures to follow. So there's things that can differentiate between different labs. So I'm a little, I would really love to see some more effort being put into the testing program. And if, say, the money is the concern, well, then is there a solution of maybe using the money that we spend on our taxes or for our registrations and things like that? Could we use that to fund, to offset some of these testing costs, or to maybe fund a state-run laboratory? I think there's quite a few problems with the way that we're doing this. And I've heard, you know, you can go back and forth with the argument, but at the end of the day, I don't understand why we're holding the medical program to a lesser standard than the adult use program, which is supposed to be used recreationally. Now we're talking medicine here, but right as it's written now, like it's legal for people to sell me oil that has pesticides in it. That's not good. But on the adult use side, there's all these regulations to prevent that from happening. And of course, there's, no matter what you do, somebody's going to circumvent it some way if they want to break the law. I get that, but I kind of want to join the adult use market now, just because they have higher safety standards, and this kind of falls along the same lines of tracking as well. And I know a lot of people don't want the tracking because it's too burdensome and what have you, but I think there's a better way to go about the tracking. I don't think what you guys are imposing is the best way to go about it, but I think there can be a lot of improvements done. And I just, while I got you here, why is the recreational product being held to a much higher health standard than a medical product? And if we're truly caregivers providing medicine, where's like the robust system to make sure that it's safe? I mean, shouldn't it be treated similar to prescriptions, down to like the exit bags and everything? I mean, on prescriptions, there's one part here that says, you know, make sure you clearly label your packaging with, you know, cannabis symbols, but at the same time, you're telling us on the exit packaging, it can't say anything to do with cannabis. So I'm kind of confused on like where these safety lines are drawn, and why is it so obscure in the medical market compared to the adult use market? I mean, this is crazy. This is why I got into this business. So if you could help, do you have an answer for that? I would love to hear.
Yeah. So as far as testing or mandatory testing or some type of testing within the medical program is not germane to the rules because it doesn't exist by law. That would be something that the legislature would have to put into the law for us to write rules around.
Okay. Thank you for your time.
Well, okay, was that it?
I mean, I have a lot. I got a couple more things that are like the tracking thing. I totally agree with the guy said about MAFCA. We're MAFCA certified, and I feel like with the tracking, it's if you're already doing this for MAFCA, now you're going to impose all these other. It's basically the same thing. So now I have to do it twice. Like this year, I had to hire a guy just to keep track of all of our inventory and all this stuff that, you know, a lot of these other caregivers probably don't have to do, but are going to have to do. And if I'm already doing this for like, say, MAFCA or something, now we got to do this with the tracking that you guys are kind of saying we should do. I think that's too much. I think there should be tracking though, because I think a lot of those dirty products I mentioned before are coming from out of state. They're either coming from the West Coast or Canada. I've seen it. I've had other caregivers tell me, offer me, and there's nothing to stop them from doing it right now other than like their word. You know, and if I get a dirty product, how am I protected? Say if I want to fight that. And I see you guys have started to write some rules about, you know, providing refunds and exchanges. I think that's a step in the right direction. But I would like to see tracking, but I think it needs to be really reworked and
if we could, moving forward, if we could find overlap with what's required for MAFCA, obviously that would require further conversations and follow-up, where you're not duplicating your effort. Do you think that might be something that, from an operations standpoint, is more feasible?
Yeah, absolutely. Because I think a lot of the requirements that MAFCA has made kind of fall in line with a lot of the things that you would do at a regular production facility or farm. I mean, I've worked on a 1 million acre potato farm, and we had to, there's logs and rules and regulations. You got to follow the USDA code and all those things. I mean, a lot of this testing, tracking stuff is kind of normal to consumable commodities. So I don't think it's too crazy, but I do feel like some of the things like weighing root balls is a little absurd. But you know, maybe if we could follow something along the lines of MAFCA, that's not too bad. I don't mind doing it. Like I said, we're kind of doing it like as a farmer, you kind of do half of the things anyway, or you should be recording your sales and inventory and you know, your crop rotations and things like that. So, but I think it needs to be reworked and a little bit more input from you know, patients and caregivers who are solely, you know, maybe operating on a smaller level and things like that.
Great. Thank you, CJ. Byrne, do you have any questions?
I do not. Thank you very much for hanging in there with us today.
Thank you.
And it looks like we have another individual that has raised their hand, Joanne Davis. So again, if you want to provide verbal testimony after Joanne, please raise your hand. I will still do a last call after Joanne has provided her testimony. I think. There they are. Joanne, you should be able to unmute and turn on your camera if you wish.
Yeah.
There we go. We can hear you.
Hi, I don't think my camera's going to work today.
That's perfectly fine.
Which is fine. So I want to thank you all for doing this today. And I'm going to be quick because I will be sending in written testimony. Most of what I wanted to talk about has already been hit upon, so I don't want to be redundant. I do think it's great that, you know, last year and this year, you guys make yourselves really available to hear from us and to hear our feedback. I guess one thing I did want to bring up is it's said, but then I'm so surprised by how similar this year's rules that are being proposed are to last year's rules. So as much as you say, you know, we really want to hear from you, but then in writing, it doesn't come through in terms of the proposed rules. And that's a tiny bit of an issue to me. I will, again, I'm going to submit everything in writing to you, but maybe, and I hate being the last person, but, you know, I just want to remind everyone what we're doing here. This is a medical program. I personally think testing is important, but because I don't know how you put a product out there that hasn't been tested. And I think you're making a good shot at working on tightening up those rules. But I guess more than anything, I kind of look at what has already been proposed. And last year I said the exact same thing. There's no rush. Let's get it right. And here we are, I feel like I'm sitting here exactly 365 days later on Groundhog's Day. And having listened to this whole thing today, we haven't made a whole lot of progress from last year's proposed rules to this year's proposed rules. There has been some positive. So just taking time doesn't seem to have made the impact that I think some of us very small caregivers are hoping. I am a home-based caregiver. I will say that having had various businesses of all sorts in many different states, and now I'm just going to kind of run through the things I have issue with. I have issue with the fact that you tell us what kind of business to organize as when it goes against what is actually written in the caregiver laws. I am actually an LLC, but I don't want to be told if I want to have a different business organization. That's something between my lawyer and myself, my accountant and myself, of how I set up a business. That's just my opinion, but I think we've heard a lot about that today. Public location is a big issue for me. I am a woman. We are taught if you're going to sell something on Craigslist, or if you're going to go on a date, to meet in a public place or meet at the police station, but yet we're not allowed to, meet at a public place to meet a brand new patient who you've never met before, and make deliveries. It just really comes to safety. I think the trip tickets, rather than having the address on them, I think we have your caregiver and you have your other store. If you're selling wholesale, you have their caregiver information and you have the patient information. I think it inhibits privacy to have the addresses on the trip tickets. I don't know if that's even something up for debate or not. I would say having one location, as you've heard, is a problem. Basically, it could be 2 rooms within the same structure. There are, and we go round and round. I heard today, it seems to me really simple. All you have to do is say, you need to tell OMP all the places you're working. And then OMP, as necessary, can inspect all those places. So I don't know why we have to put a number on it. We've heard about people who might be renting a field a mile down the road for the outdoor. All we need to do is tell OMP where we're doing it, and then OMP can come inspect like they do. And that just seems fine to me. I don't think we're deterring, the traditional market, i.e. the illegal market. Those people aren't going to come and register with you anyway. I don't think, we're really trying to say we have 3,000 small businesses here in Maine that are caregivers. Let's not put us out of business. We make such a massive contribution. I believe, I don't know what the statistic is. I can never remember the exact. We seem to sell more than lobsters, or we're the biggest amount of agriculture, whatever the statistic is. Let's not forget that it's 3,000 people just trying to make a living. And we want to do it honestly, and we want to pay our taxes. And we don't want to be treated as people who are criminals. So I think maybe in closing, if we just kind of remember why we all came together, why we're all here, it's that it's 3,000 people offering jobs and businesses to this great state. And let's not put us all out of business, and let's not, let's not go too far. Let's really work together. I think a lot of really great ideas were brought up today. So I'll do everything else in my written testimony, but you know what? A year later, we've spent a year, and I don't know that we're that much more together in feeling like the small caregiver feels heard. So I'm just going to thank you for your time.
Yes, thank you. And thank you for the written testimony. And hopefully we can get, as you say, get a little bit closer with the work that we have cut out for us over the next few weeks and months as we consider obviously the testimony that we got today, but all the written feedback to see if we can't get to a place where this rule serves its purpose for clarity and serves all stakeholders. So certainly, thank you for joining us today and giving your testimony. Vern, did you have any questions?
No questions, just another thank you. We appreciate your help.
So with that, it looks like we've come to the end, but I certainly want to give time if there's anybody that has not provided verbal testimony, neither for nor against or opposed. If you could use the raised hand feature, I will give it a few more seconds. Certainly, again, don't want to close the public hearing if you want to be able to provide verbal testimony. I will remind the group that there is still the opportunity to submit written comments that runs, what was the date? Until Sunday, February 13th, 2020. Going once, going twice. Okay, with all testimony having taken, the public hearing on OMP's proposed rules is now closed. As a reminder, public comment will be accepted until 11:59 p.m. on Sunday, February 13th. So still opportunity to provide us that information that we can consider as we continue our work. Comment or written testimony may be submitted through the OMP website or forwarded to the attention of the Office of Marijuana Policy at 162 State House Station, Augusta, Maine, 04333. Or you can find email for our Director of Policy, Gabby Pierce, gabiperce@maine.gov with the subject line rulemaking. Also, I think all of our information as far as how to get us that written comment is also on all of our social media links, Instagram, Twitter, and Facebook. And our general contact is on our website if you have any further questions or are trying to get us that written testimony. So with that, I thank everybody for their time and attention to this important matter. I obviously thank Vern for joining me today and my team behind the scenes helping facilitate this this meeting. So with that, I'll close the meeting and till next time, thank you, everybody.